Well, hello again, everybody. It is Tuesday, December 23rd, and I am Alison Motta, and we are here with our continuing coverage of the people of Indiana versus Richard Allen. And for our Richard Allen appellate brief recap, you have myself and the renowned Andrea Burkhart, who I know needs no introduction here, so let's just bring her on. Hey, Andrea.
Hey girl, how you doing?
Pretty good, pretty good. I know we both, hashed through this entire thing on our respective channels with our respective people. And I guess now's our chance to kind of take a second look now that we've had time to digest.
Exactly, and kind of refine a little bit. I don't know about you, but I wasn't expecting to stream for 6 hours with my thoughts about the brief, but
Well,
that's just kind of what happens sometimes and you roll with it.
yeah. And I always like to catch your lives because I respect and appreciate your opinion on things and your take on things. I know that you do appellate law, you know what you're talking about, but I even more so did just because we were going to do this. So I kind of knew where you were at, but I could not get through all 6 hours. I kept trying and restarting. And so I apologize if there's stuff that you said there that I'm, just not aware of, but
I am not going to hold it against you whatsoever. And just to kind of return the compliment, I really have enjoyed your streams with Michael Osbrook because something that I know we have talked about before is that there is absolutely no substitute for knowing your jurisdiction. And it's the disadvantage that all of us who don't practice in the state are always going to have when we're looking at a case. Anybody can look at the law and see what the law says and figure out where to find it and so forth. But there's so much that happens in court that isn't written down anywhere. And there's personalities at play that if you're not familiar with, it's just a whole piece of the puzzle that you're missing. So having that hometown perspective from Michael Osbrook is super valuable and really, really have enjoyed that a lot.
Yeah, and speaking on that, before we get into like our overview opinions, there was a lot of things where, in Illinois at least, I'm reading appellate cases all the time where the court's like, well, you didn't flesh that out enough. You did like a bare citation without telling me how it applies to this case or even giving me, like a general overview of what that case was about. Even in a parenthetical, sometimes we'll catch shit where you just kind of give the summary there. And, Michael seemed, unless he's just afraid to say anything negative because he's obviously wants this to go forward. But I'm like, the panel's not watching us. That's for sure. The judges on the panel aren't watching us. But is that something in your experience that you see courts often saying you didn't say enough here, you didn't cite enough here?
Absolutely. It's just one of the things that they have in their back pocket if they want to punt on an issue and not really have to engage with it. It's not adequately briefed. We have cases in Washington that I don't remember the citations offhand, but I remember the case language, offhand, because I've seen it so many times. Court has no duty to, address issues that haven't been adequately briefed by the parties. The parties have the responsibility to cite to the applicable law and the points in the record that support it and so forth. So if they really want to give you a hard time, and not address something that they think you haven't adequately addressed, they have the means to do that. Now, I will say that at least over here in Washington, it's not common that they'll do something like that. It's usually got to be pretty egregious, like you have just said that there is an error, but you haven't really dedicated any argument to it at all. You've just kind of, bare asserted it, and not fleshed it out in any meaningful way. But that's my hometown. That isn't this hometown. So I got to defer to Michael Osbrook on how
Yeah.
they're going to do that.
He seemed to think that the sites that I asked questions like, "Well, here they didn't really tell them anything about the case. Is that gonna be a problem?" And he said, "No, he didn't think it would." So, hopefully it won't.
Allie, throughout the brief, I mean, I know we're going to get into kind of a lot more of our thoughts, reactions to what we've read here. But I will say one of my kind of big picture takeaways is that I was kind of surprised at how light on legal analysis the brief was. There was clearly a very, very heavy priority on facts, on not just like the statement of facts itself being 46 pages long. A significant amount of the space that they're allowed in their brief was just devoted to recounting the story of what happened here. But also, as you went through the individual assignments of error, there's plenty of citations. It's not that there's no law in the brief, but there isn't really a lot of explanation of what that law is, and laying it out in a way that we kind of become accustomed to seeing in the appellate context. We're used to seeing, this case is cited. Here's the facts in this case. Here's how they compare to this case. Just a little bit more detailed discussion of what the law is. And that's really absent from pretty much all of the brief, from what I read.
Yeah, and that's exactly what my concern was when I talked to Michael, and he seemed to think it was sufficient and the court wouldn't give much kickback. But like you, and there were like specific times where I would highlight, all right, they just cited this case. They did not tell me in any way, shape, or form how that applies here. What about it? I don't even know what that case is about. So I feel you from that perspective. And I wonder, do you think, as far as being very fact heavy, one thing that I contemplated was, is this because of like the harmless error test? So that
Mhm.
when they go back to decide, is this harmless, they can see this full picture that calls into question the investigation, the evidence against him, and determine that the evidence against him was weak, or the state's case was not strong, and that would weigh in favor of finding that the error was harmful.
That's a good perspective on it. I really hadn't thought about it in those terms. My kind of take on it, honestly, was just a little bit more motivational. I am somebody who does believe that most of the time, what wins your case on appeal is your facts. Your law is great, and you really need to be able to present a legal framework to give you the remedy that you want. But it's really the facts that persuade the court to want to give you the relief in the first place. And so I think that was such an important part of this case because, number one, they have the facts. I mean, the facts are so egregious. They work so powerfully in the appellant's favor. But I think also just to kind of overcome as best they can the natural resistance that the court is going to have to rock the boat, to unsettle the settled decision that's come down. It's so easy for them to just wipe their hands, say, nope, we had this trial, it was long, it was expensive, we don't want to do it again, we got a jury verdict, and so we're going to just go ahead and let things stand. You really have to give them a little bit of a kick in the pants to get them to see that you shouldn't actually want that. Like, for all of these reasons, it kind of makes you guys look terrible if you do. So I think your point is very well taken. It does play into the harmless error standpoint because the court needs to understand the whole perspective of the case, both in terms of what the defense was allowed to do and what they were not allowed to do, in order to really be able to evaluate what is the effect, either individually or potentially cumulatively, of these different errors that have been assigned.
Yeah. And to your point about, them being very fact heavy and how important the facts are, and it's something, Michael's repeated, and I know you and I have repeated that because the court can do what it wants, basically. The law is there in a way, and I know you've gone over it, how the hurdles that you have to go through to do what you just said, to get them to change a decision already made, that they can do whatever they want. So with all those facts, you're hoping that they're getting a taste of something stinks here. So I'm going to take this opportunity to do what I want in a way that would, overturn the conviction, remand it for whatever, whatever the case may be.
Yeah,
Um,
I mean, you're trying to take your finger and, like, jam it into their conscience a little bit, like, get them to kind of wake up. This is not a normal case in so many ways, and I think that it's important to have the perspective of what the appellate court is seeing the vast majority of the time, because the appellate court sees a huge number of criminal appeals, and the overwhelming majority of those criminal appeals are cases where the defendant was indigent. They had a right to public defense, so that it's not a situation where somebody has financial skin in the game, and they also have a right to appeal. And so, you know, pretty much any case that goes to trial and results in a conviction, it's going to be appealed, because why not? There's not really a good reason not to, and you don't necessarily have anything to lose, and potentially a lot to gain. So courts see a lot of really marginal appeals to, like, almost frivolous appeals, things that there's just not a whole lot to work with. You got to kind of reach for some kind of argument. Maybe you can find a legal error, but just the facts are so bad that trying to fit it into an argument that it had some practical effect on the outcome is really challenging. So that's what they expect. That's what is normal for them to see, is cases where it's just kind of pro forma. They know that it's going to be affirmed. The attorneys know it's going to be affirmed, but everybody's just kind of doing their job the best they can to make the case. This is very different from that, and that's precisely what this heavy emphasis on the facts serves to emphasize. Is that, if you thought this was just going to be another appeal full of some reaching, issue that maybe wasn't even preserved very well, or maybe was kind of, there's a good argument it was waived, or maybe there's a lot of law against it. I mean, all of that type of thing. This is not it. This is one where there are serious questions about whether a grave injustice has been done here on multiple levels, not just the pretrial treatment, but the misrepresentations to the court, the deception that the entire case was based upon, and then the hog-tying the defense when it came to trial. These are facts so unlike most cases that the appellate court sees, that they really are attention getters, and encourage them to start getting in the mindset of, this case is different, so you need to be prepared to treat it differently.
right. And so to your point, that's why heavy on the facts in this scenario. Yeah, I mean, it's definitely important, and I agree. I think it's just not your usual case, from procedurally to factually to, from start to finish. And
And to your point about the judges can kind of do whatever they want, the law is quite plastic. It's not that uncommon to be able to find language on pretty much either side of a legal issue, depending on which way you want it to come down. You can find cases where, on this particular legal topic, the court ruled in your favor, and you can find very friendly language that you can cite. The state is going to be able to find cases where they ruled against your position on this issue, and there's very unfriendly language that they can cite. So there's kind of always something there that the court can can hang its hat on, just depending on the direction that it wants to go. So the law is a helpful tool to get them there, and you certainly need it. You have to have some kind of legal hook. You can't just be like, look, this was obviously unfair. You have to have some kind of a legal avenue for them to get there. But the law itself is far less influential in driving the outcome, in my opinion, than a lot of people might think.
Right. Yeah. And is there anything else as far as like the 10,000 overview you want to say before we delve in?
Well, let's say on a scale of 1 to 10, how confident are you that this brief is going anywhere, that it's going to get anything done for Mr. Allen?
I mean, it's horrifying to think of because if I'm being realistic, like a 6,
Hmm.
I want to say higher,
Hmm.
like, but it's just so hard. I mean, but there are some really strong arguments, but I'm just so used to the court, finding a way to say no. I
Hmm.
don't know. What about you?
Well, it's funny you say that because I'm at right about a 6 to a 6.5 too, which from my perspective, as a longtime defense appellate attorney, is really pretty optimistic. Um, the odds are always so against you on appeal. The standards of review are against you. You have all of the same institutional kind of biases that you have when you're a criminal defendant sitting at a table and the jury walks in and like, hey, what did he do? You have the same thing, maybe even worse on appeal, because now you no longer have a presumption of innocence. You're just some guy who was convicted, and like, what's your story going to be? So you're always on the back foot. The standards are against you. You have a tough challenge, but he does have the facts on his side. He's got a very good story, a very unusual case in terms of how everything is unfolded, and I think that's also been articulated extremely well in this brief. They did a very good job of showing not just what happened, but also how it's unfair. And then to add on to that, I do think that they have some legal issues that they've identified that are pretty strong. They're on pretty good footing, uh, and so I mean, I think it is definitely worth having at least a little bit of optimism about how this could go.
All right. Well, that's good to hear. And, for all you out there, before we get in deep, we are going to answer your questions. I'll be keeping an eye on the supers and ask them along the way. So don't worry about that. And then, so, all right, let's start. I know because I heard your opinion of the Franks hearing, which is issue 1, that
Mhm.
you did not believe it was really their strongest, but you felt it was the way they wanted to tell the story.
Yeah, my view on the Franks was this. I don't know that they really want to win this because the remedy for this is not particularly good. It's extremely unlikely that the Court of Appeals is just going to decide independently. All of this evidence needs to be thrown out, and the case needs to be retried without any of it. It's far more likely that they would just send it back to Judge Gull to do the hearing, and then Judge Gull is going to, couch all of her findings and determinations of credibility that are basically untouchable on appeal, and make it that much harder to get any kind of real relief. So, in terms of it being like a good issue that you want to win on, this one is not it. Now, I think it's factually pretty well founded. I think they've made a very good showing that there are some significant misrepresentations and omissions here in what happened. I think part of the challenge is you're always dealing with that harmful versus harmless error on appeal, and the probable cause bar is pretty super low, and so I'm honestly not sure that even if you take all of this stuff out that Liggett made up, or the stuff, add in the stuff that he failed to mention, I'm just not sure that it would totally undermine their ability to say, hey, he put himself there at the right time. We don't have anybody else that's there at the right time. And so does that in and of itself just warrant, some type of ability to do further searching.
Right.
But I think it was important for them to include this issue, uh, because it does. It sets the stage for the whole legal argument. With this whole thing was built on a lie, and it was a huge theme of the defense's argument that the state had to build this case. That this didn't just evolve from the evidence. They had to build it, and in part of building it, they had to destroy. They had to crush what the defense had to work with over here. And so this set the stage for the court. The very first thing that they're reading is about the fundamental deception at the very outset, from day one. This was never going to be a process that had integrity. It was never going to be a process that could be relied on to be fair. And so that in and of itself is an important part of the story to tell.
Yeah, and I agree that even if they didn't think, and now Michael, he thought that they thought it was one of their strongest arguments, but I
Mhm,
agree, considering that the very likely, even if they agreed to it, it would be an unusual turn of events for them to say, "We're deciding the issue. We're not
mhm,
even making you do a Franks hearing. We're saying
mhm,
this is all out," because that would just, it would be unprecedented. But
mhm,
like both the non-legal word for use of the word and the legal term, but and that the remedy is go have a hearing and then you're back in front of Judge Goal. And I've always tried to explain this to people from the beginning. They're like, why didn't she didn't even give a hearing. She didn't even give a hearing. And I'm saying, well, look, in theory, I'm not, maybe I'm giving her too much credit because I don't even know if she ever read the entire thing. But in theory, had she said, I'm going to accept everything the defense says as true, which she would have to do for these purposes. And I am deciding that even if every word that they wrote on here is true, there was still sufficient probable cause, which is
mhm,
what you're talking about here, that the probable cause, you know, the whatever is so low
mhm,
that, even without it, she can turn around and say, I still find probable cause. Now,
mhm,
the hope might be if they were sending it back for a Franks hearing that maybe they point out enough, like that is possible, that they point out enough that they found, took issue with, where they can signal the court, like, I think you need to take this very seriously, and
mhm.
it very well damn well could be inadmissible after a Franks hearing. There might not be probable cause. In your opinion, what is how often do you see it? Is it even possible that the court will use some heavy language to signal to the lower court what they want them to do on remand?
I mean, they can. It's definitely not unheard of, but of course it's not binding. And so that's the problem that you end up with. You end up with this kind of game. And we've already seen Judge Gold does not mind at all disregarding the instructions that she's gotten from the higher court. They made it very crystal clear that she needed to abide by the rules on access to court records, and she has flouted that. I mean, pretty much since the moment it got put back into her court. She's continued to seal stuff away without following the appropriate procedure. There's all kinds of stuff that's confidential with no ACR forms, none of the required findings, and so forth to justify that. So the nudge from the higher court, we already know that that's not effective. Now, is the court going to kind of
Try.
be aware of that history and take that into account? I don't know, but I would be skeptical. I think in this situation, if they want to do something, they will. But if it's something that's in Judge Goal's bailiwick, to get to do, then they're probably going to let her do it. And that's just
Nature
it's
of the
the
beast.
unfortunate reality, the nature of the appellate court. They don't decide things. They don't like to be in the position of we're going to be the ones deciding what the facts are. We're going to be the ones judging whether this is misleading. They don't want to be the ones making the decision in the first instance. They're there to review what other people have already decided, and so that's, I think, just the most likely outcome in this particular case. And because of what a problem Judge Goal has been here since day one, we can already anticipate she's not going to give that argument a fair shake. And so, does it even really accomplish anything? I mean, I guess it's technically like a win on appeal, and it's good in that sense. But in terms of achieving something material for Richard Allen, I'm just very skeptical that it would.
Yeah, and your point is very well taken when you say we've seen her not care because, we'd like to think for the most part judges care what the appellate court has to say. They don't want to be reversed and they will take their cues because they're supposed to take their cues from a higher court, but as you're pointing out, she already didn't take their cues. So,
She
yeah,
doubled
you're right.
down. She
Yeah,
doubled down. It's almost like she took that as a make me, you know? I
right.
mean, it's astonishing. I've never seen anything like this judicial demeanor that we have seen from the bench.
No, your point's very well taken. So there's that. All right. So of the Frank's issues, you've
Mhm,
got that Liggett omitted and changed key information that undermined his conclusion that Allen was bridge guy. And
mhm.
then one of the benefits, and I know everybody knows what it looks like, but I'll just put it up, just in case. And although it's in the statement of facts when you talk about a strategical decision to start with the Franks memo and to start with the Franks issue and to start with the facts that go along with that, you get this again right in their faces about
Mhm.
how this is the sketch that they told the public was Bridge Guy. That this
Yep.
is what the sketch that one of their witnesses said the guy looked like that was never told to the judge who issued the warrant. So,
Mhm.
having again, it was in the statement of facts, but it's the first thing they're seeing when they get to argument, and I do think that that was important to have right in their faces again.
I agree completely. I love that they included the visual in their brief. I love this is always a smart thing to do. I think when the picture speaks a thousand words. I would have loved if they had pulled one of those exhibits that the state had
Yep,
introduced at trial that showed what Richard Allen looked like in
right.
the same time frame, so that they can see for themselves. This is the guy they are saying is
Is
this
this
guy.
guy.
We can say over and over again, well, he doesn't match the description, and of course, I think they do a good job with their language of explaining why he's in his 40s, he's short, he's got a shaved head, he's got a goatee. So all these things don't really match, but for the same reason, being able to see it with your own eyes would really be extremely powerful.
Yeah,
But
and
that how well does that set the stage? I mean, once again, their whole investigation started with Bridge Guy, and they have ended with pinning it on a guy who looks nothing like Bridge Guy.
right. And to, I don't think it's right in this section, but it was up there and it might be below. I don't know. But when they show the video picture, the guy's head is completely and totally obscured. There is
Mhm.
no way a witness sees his hair, and leaving everything else out. Like, okay, this chick just sees young, handsome men wherever she looks. There was there was a hat on his head.
Who can blame her?
Right, right. There was no ability to see hair, no way
Mhm,
to say what the hair looked like, and that was one of the key points of her description. So, I
mhm,
think that that's important as well. But one of the things I want to ask you about also is the car. Now, in the
mhm,
statement of facts, they included that it was a comet. Because
mhm,
here I said, I wish they would have put a picture of a comet.
mhm.
Like what the is that what it's called?
Yeah,
A
the Mercury comet.
Mercury comet. Because all it says here in this part is that Blair saw a man on the bridge. She saw two girls she thought were Abby and Libby on the trails approaching the bridge. As Blair was leaving the trail, she saw a car oddly parked at the old CPS lot. Around 2:10, another witness, Wilson, also saw a car backed in the CPS lot as if concealing the license plate. Both witnesses drew diagrams of the car parked in the quote same general area.
Mhm,
Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during that time frame of the kidnapping was not black and had sharp angles like the sketch below. So
mhm.
they don't restate the fact that she also said it was a What kind of car?
1965 Mercury Comet.
A 1965 Mercury Comet. Now, in my experience, sometimes the court's like, "Well, you said that in your statement of facts, but you didn't incorporate it into your argument."
Mhm.
Do you see that as a potential issue, or you think, "Oh, no, they can
No,
refer back and"
I don't think that will really be key because they've said enough to really make the point here, which is just the fact that there's a discrepancy between what she described and what Liggett is saying the facts are is really the nature of the problem. I think that the challenge with the car is that you have the other statements that Wilson made, where he said maybe it's like a purple PT Cruiser or a small SUV or something like that, which still is not describing this black Ford Focus, but it's at least a little bit more in the universe of what the car looks like. Uh,
Right.
and so I think the issue with the car may come down to, well, is that really going to tilt the scale? Because it's kind of normal to have differing memories, differing accounts of things. People get some things wrong and some things right. It's kind of a cliche that multiple people can watch the same incident, and come away with it with dramatically different, memories of what they saw. Um, so I think the fact that Wilson has that competing description is a little bit more of a challenge for this particular part of the Frank's argument.
Right.
Um,
Did
but
they not put that was also not in the
it's not in this
application?
argument part. It was included in the statement of facts,
But
but they didn't include it in this argument.
was it included in the affidavit? He didn't mention it in the affidavit either?
I don't believe it was specifically mentioned in the affidavit. I would have to go back and double check.
Yeah, I just tried to look and I couldn't tell. Let me just check one more time because if it wasn't in the affidavit, then I think that you're right. Absolutely right there. So the story the detective Liggett told the judge, um, also Liggett concluded that his black Ford Focus was parked. He claimed the witnesses saw a car backed into the parking spot. Wilson felt the drive. So this might be her saying it was included. Wilson felt the driver of the car was driving to conceal the license. Wilson said the car was a purple PT Cruiser or small SUV type. Blair and Wilson drew a diagram
Mhm.
and had the vehicle they saw parked in the same general area. So I was
Yeah.
taking this to mean he actually said it in there that Wilson said the car was a PT Cruiser or
No,
small.
I think you're right. I think that's what that citation is referencing, that all of those can be derived from the affidavit itself there in the record.
Okay.
Uh, so the issue is just, does the fact that Betsy Blair's description conflict with that, does that undermine, Wilson's description? I mean, it creates a
Especially
conflict, but
right.
does it preclude you from being able to find probable cause? That's where I'm a little skeptical.
Well, I think the car would be out altogether because you had the first guy described a purple PT Cruiser. I don't think that looks everybody knows what that looks like. And the to have another one who described a different vehicle, like he was like, all right, I'll throw this one in, but I'm leaving out a 1967, whatever the case may be. To
Mhm.
me, I'm just like, all right, they put it here, right? That she specifically said it was not black. And I know they're
Yeah.
conscious of the words, but then they put it one more time. Oh, no, maybe not. So, I don't know how many words it would have been to say was not black, comma, looked like a comet again.
Mercury Comet, yeah.
Right. Even if you just used Mercury Comet or a 1967 vehicle that had sharp something. But
Mhm.
um, I I see your, if it hopefully won't be an issue like they did put enough. So as far as misdescribing the that key information which starts with the description of him, the car, then I think the last thing is that Carball said the man was, muddy
Mhm.
and bloody. And I know you mentioned this and I don't know the answer because I heard you say what we don't know is when. Could it have been at some time before the subpoena was written, that she first made a change?
Yeah, because she did. We remember that from the trial that she changed her story. She was led from tan and muddy to blue and muddy and bloody, and it occurred over the course of several interviews. And my recollection is that that all took place before the 2022 search warrant, but I just don't recall specifically. I think that that timeline does matter
Right.
because if she got there and she said it before, he put it in the affidavit, then it's not a lie. Now we could be in a position of, is it an omission to not mention that that wasn't how she described it initially?
But that's a
And
lot weaker than if she hadn't said that at all.
well, it certainly undermines her credibility, doesn't it? And the whole credibility and veracity of an informant is critical information that you're supposed to include in a search warrant. You're supposed to give the judge enough facts to be able to evaluate, is this good information? Can I rely on this person that's recounting it? And so if her story's evolved, that undermines the
No, that's a
credibility
very
of the
good point.
witness. Now, enough to again take it to the point where you'd say you can't find probable cause based on that. I'm a little bit more skeptical of that. But I do think that timing could kind of affect the framing of this particular issue, but not necessarily undermine it in a specific way.
Right. And then the last thing about that, well, part of that also was that Blair told the man on the told said that the man on the bridge was not the same person Carball described. So they could
Yeah.
just say, "All right, I'm tossing Blair out altogether." Um, which I guess for a probable cause affidavit they could decide to do, and it wouldn't change that you've got all these other people who are at least saying they think they saw a person that looked similar to Bridge Guy. And then the
Hmm.
last thing was that Alan admitted to wearing, a black or blue Carhartt and head covering. That might be uh, do you think that's a strong one, that specific portion?
Personally, I do. I feel like the misrepresentations of what he said in his interview are pretty strong because they're pretty blatant,
Right.
taking his words and twisting them into things he never said. He never said he drove the route that they said he said. He never said he parked at the place where they said he parked. He never claimed that he was wearing the clothing. And those were, important parts of the search warrant, but also ended up, becoming fairly important parts of the trial as well.
Right.
So I mean, we have a transcript of the interrogation. We can watch it for ourselves. We can listen to it. You can see that he does not say these things that are attributed to him. And so for me, it's hard to see a way to twist that to suggest that he did in fact say them. Uh, that takes a lot of the law enforcement having to inject their own, I guess, desires of what they thought he said or wanted him to say, that he objectively did not.
Yeah, no, I thought for me that 4th one was a very strong one as well. Like the fact that they're making it sound like he said he admitted wearing a black or blue Carhartt and head covering. And, was it in the affidavit, and maybe we might have to go back up and check that he um that other piece that you just said that he thought he drove that route, or that wasn't part of, no, because that happened after, right?
Yeah, I think I don't remember if that was in the Mullen interview or in the Holman interview.
But it would have
So
been
I
after the
forget
search warrant.
I forget the
Yeah.
exact order of that. Um, I
But
think
the
that
other
actually was in the Holman interrogation.
so
So they
that
they didn't bring that up in the search warrant, that particular part of it, but it was part and parcel of the same game that they were playing that you saw in the search warrant preparation.
For sure, for sure. And then the other thing I have always felt when he says originally to whomever the officer is back in what 2017 that an argument could be made, he said between what was it 1 and 3, not from 1 to 3. Like I was there sometime between 1 and 3. And
Well, the time frame here, I think has always been a little bit of an issue because we have the 1 to 3, we have the 11 or 12 to 1 or 1:30 or something like that. We have these different accounts of what he said. Now again, conflicts in the evidence, not going to necessarily be a great avenue to go down in terms of trying to undermine probable cause.
Right.
Uh, but it is just kind of part of the story too. They're trying to make it as incriminating as possible what's coming out of his mouth, but when you go back and you put it in context, that just it really doesn't seem fair. I think in that particular instance, the fact that the timing was kind of over the place is why they didn't raise that as a specific basis for one of the misleading facts or omissions or something like that in the warrant. But it's certainly part of the big picture.
Yeah, and I have just always taken issue outside of the affidavit for Franks. I've always taken issue with the everyone saying he made an inconsistent statement, because I'm like, words matter.
Mhm.
Between 1 and 3 is not the same as from 1 to 3. It's like, "Oh, I was
Mhm.
there sometime." To me, it could be interpreted very easily and naturally interpreted as, "I was there sometime between 1 and 3," not, "I was there from 1 to 3," you know?
Yeah,
So
absolutely. I think that's completely legitimate. And, anytime I read a police report or an affidavit or anything like that, and I see a characterization, it's a red flag because, the police officer's opinion doesn't matter. It's like one of the least relevant things in the entire process. And so anytime they're trying to substitute and like push their opinion in there as being something that should drive the decision making, it just tells me that we need to look at the facts, because if the facts were supporting this characterization, you would just tell me the facts. And you see this kind of over and over and over again when cops will say things like, "Oh, he changed his story," and then you go and you look at the transcript, and no, he actually just provided you additional details that you had asked for, kind of thing. So stuff like that is always a little bit of a red flag that should get your attention to dig a little bit deeper.
yeah, and in pretrial practice, I'll tell you, I have never, and no lawyer should ever, taken the word of the police officer's police report of what somebody said, because 9
Yeah, don't.
times out of 10, when you listen to the actual audio, that is not what they said, and like you're saying, they take things out of context. They "What? I killed the clerk? I killed the clerk." I mean,
Yeah.
that is like the perfect, you know descriptive of what happens.
Not to
So
jump too far ahead, but, I'll tell them whatever they want to know is what the cop says he says, but I'll tell them whatever they want me to say is what the transcript says he says, and those tiny little tweaks can make such a huge difference, and unless you're listening to it yourself or watching the transcript yourself, you're not gonna know.
And that kind of goes to our like the second part of the Franks issue of being able to establish a reckless disregard for the truth or intention. And you
Mhm,
saw them do that here, the defense originally at trial level, point to other instances where they have taken, misrepresented something, stretched the truth,
mhm.
taken extra, what's the word I'm thinking of?
Liberties.
Liberties, right, with what was said and what happened. And, they you've heard, people giving the defense shit like, "Why are you bringing up all this stuff? It has nothing to do with what was in the affidavit for probable cause," but it goes to their state of mind. It goes
Yes.
to what they have been doing throughout the investigation. And when we talked about it the other day, someone said, right, a pattern of behavior that they can
Mhm.
use to establish that intent. And in appellate work, this is probably not an issue that comes up that much, but have you ever come across that where they have taken other acts out that, of the same officer or the team that were not directly tied to the statement of facts to say, "Yeah, I see they pulled shit over here, they pulled shit over there, so I'm more likely to assume they pulled shit here."
Yeah, I can't think of an example off the top of my head that really fits this particular context. Where I'll say that I do see stuff like that with some frequency is in the prosecutorial misconduct arena, where you might have a particular issue, and maybe standing alone, it doesn't look that egregious, but when you put it in the context of all the other shenanigans that they were engaging in, it really does put a different color on it. And so we have a few cases in Washington I can think of off the top of my head where, like, yeah, it's the repeated and kind of ongoing nature of it that speaks to it being particularly flagrant or ill-intentioned, or whatever. So, I mean, I don't think it's unprecedented to apply that kind of standard in a context like this, where we're looking at the law enforcement conduct in trying to build the case against this guy. And so, what did they do similarly in that same context that can shed light on why were they doing this?
Right, and we see it nowadays with the Brady stuff and what the prosecution might have to turn over about a specific officer who's going to testify, that now they're realizing, "All right, well, we have to determine, is there a pattern of a little thing here, a little thing here, a little thing here that rises to the level of a pattern of taking liberties, of some sort of misconduct, of things like that." So, the
Mhm.
court's starting to recognize that is something we need to look into, and like you're saying, same thing with prosecutorial misconduct. Well, look at what they did over here, with all that
Mhm.
kinda coming together, so, you
Mhm.
know, and just to Bailey was asking, I know the AG who responds for the state is who responds for the state, but will the AG refer back to Nick McClelland for input, or do they purely respond based on transcript and evidence? Do you know what their typical practice is?
I have no idea what their culture is here in Indiana. I think locally, where I am in my practice, yes, it's very common for the appellate attorneys to confer with the trial attorneys. You kind of need to get their perspective on the stuff that you can't see. I mean, yes, you have the transcript and the exhibits and everything, and that's what your argument is ultimately have to be going to have to be grounded in. But you don't get nuance from the transcript. You don't get tone. You don't get that culture that we've been talking about, because there are kind of like I was saying with this first issue of the Franks. Like, do you even want that remedy? None of that is written here in this brief. You're not going to know just from reading the brief that, like, it might not be a great thing to send this case back to Judge Gull. You
Right.
have to kind of know that from the context and the experience of being in that courtroom and so forth. So it's very common to have consultations like that, and to bounce ideas and get perspectives and so forth. But when it comes to the actual writing of the brief, it's going
Right.
to have to be based on what's in the transcript, or the exhibits or the filings, or whatever, just because that's what you have to work with on the appeal.
Right, and I didn't get the sense that Nick McClellan is the type that has any sort of, great visions, or, a great legal mind that they're gonna want his input on the actual, defending of the issues or countering of the issues. I mean, he didn't even attempt to thwart third party, evidence of third party suspects until the judge told him to.
Hmm.
I mean, I was asking Bob about this, like, months beforehand. I'm like, "Is the defense going to give notice that they intend to raise third-party suspects? Are they going to front this?" I mean, like, in my experience, that's what you typically are supposed to do, is let the court
Hmm.
know, I'm gonna raise reverse 404B, evidence in this case." Or are they just gonna take their chances and call the witnesses and see what happens? And it got to the point that it seemed the defense was just gonna take their chances and see what happened, and the
Hmm.
prosecution did nothing to try and stop that, knowing that was the direction, knowing these witnesses were gonna be called, until the judge says to him, "Hey, they gotta meet a threshold before they can bring this evidence on. Maybe you should raise that to me,
Yeah.
Mr. McClelland." So I can't imagine that the AG is gonna be looking to him for his legal insight, but like you said, for a feel of what happened, for, all the other things that you can't get from the papers, it seems a likely scenario. So then the next thing that they touched on was um, the other omissions that, I think that was just really summarizing in this next section, the same
Hmm.
ones. So of all of those, you know, the request for reversal, we sort of touched on that we both think it's very unlikely that they're going to say that that evidence should have been suppressed instead of sending it back
Mhm.
for a Frank's hearing. Um,
And, their request for relief, I think, also kind of highlights another reason why it's likely to go back is because the determination of what is actually the fruit of this poisonous tree, if we conclude, it is a poisonous tree, that's going to be a question I don't think the Court of Appeals is going to want to decide in the first instance either, because they haven't been part of this process. They are looking at it from a bit of a distance and just in the context of how things were presented. And so to the extent that the defense is wanting to extend that fruit of the poisonous tree doctrine to Richard Allen's statements many months down the road when he was in custody in Westville, they have an attenuation problem with that. There is a lot that happened in the meantime. There were a lot of decisions that were made that went, far beyond just the natural things that flow from a search warrant being signed and executed that were required to kind of get them to that point. And the record is not really fleshed out on how or why should that be treated as causally linked so closely to the illegal search that it should likewise be suppressed. So that's the type of thing that you would expect the trial court to be making the first kind of decision on. What is the scope of what's affected by any problem with the representations in the warrant? And then the Court of Appeals would look at it, in a review setting once again.
Right, and that makes sense. So everyone, what we're saying there is that, if it gets remanded, that means sent back to Judge Gold to decide. And let's even just say she says, "You know what? That warrant should have been that warrant should not have been taken place and the evidence should be suppressed." We're talking about the fruit of an illegal arrest. What did they derive as a result of that arrest? And that's where Andrea is saying the appellate court doesn't want to be the one deciding that issue, nor is this record fleshed out enough for the appellate court to do it. The brief tries to stretch all of that to not only suppressing the bullet and the testimony about the bullet, but also the confessions that came later. And, which that's where Andrea is saying, well, you're going to have this attenuation issue. Are those confessions really tied to the illegal search? And then that's an issue that the appellate court's not deciding on their own, which is more reason why they would send it back for remand. All right. So
Mhm.
anything else you want to say about the Franks issue?
I think we've pretty much covered it. I mean, I think bottom line for me, it's not a bad argument. I think they're in a good position. They got good facts to support it. It's just a question of, is this even really going to be helpful to you if you get what you ask for?
Right. Right. I mean, I guess if it's like I got nothing else and I've got this, maybe it turns into something, but your point's well taken because once again, like we're saying, once the trial court and one sure thing you can expect, if the appellate court gives those little hints of what they expect or where they see issues, when Judge Gull ultimately writes her opinion, or she's going to touch on all of that. She's going to dot her I's and cross her T's to make it really hard for an appellate court to say that she missed something or that she should be reversed for an abuse of discretion,
Mhm.
which is that's that if you don't want to get reversed and now it's being sent back to you, you're going to make all of those decisions like you mentioned earlier to be on reliability, like what she took a witness's credibility
Yeah,
to be.
credibility issues are, like, untouchable, and so that's one of the classic ways that judges will insulate their decisions against appeal. They just decide all the facts on credibility. "Oh, the officer says this thing, and he's contradicted by 10 other witnesses called by the defense. I'm just gonna find that the defense's witnesses aren't credible and the police officer is." And even
Right.
though that seems, implausible and unreasonable to an outsider, just given the standards of review and how they get applied, the judge has the power to do that. And that's why it's so important to pick good judges who will not use their power to make those kinds of decisions inappropriately.
Right, and the reason for those of you out there that the a credibility issue is basically you can't mess with it is because that judge is the one who saw the person testify, who watched the body language, who saw their faces, who heard the words. So that's why they give so much deference to a credibility determination because you can't determine tone, context, body language, from a transcript. So that's how why that insulates a judge's finding so much. All right. So the second one, the trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in maximum security prison. And for this, we're just dealing with the mostly the constitutional issue.
Mhm.
Was his statement voluntary? Should it be suppressed because of the conditions? Now, when
Mhm.
I initially thought about this, I just was having a hard time separating the fact that there's no police interrogation here, like
Mhm.
the fourth, the fourth, Fifth Amendment argument from the fifth, sixth due process amendment argument, because so oftentimes that's the analysis that the court gives, and it starts a lot of times with, did a police officer or state actor question this person?
Mhm.
And obviously, typically you're dealing with confinement conditions pre-arrest, pre-trial, so it's very unusual that you're dealing with a post-charge jail conditions, as as what makes something involuntary. When you look at this, can you see the court finding not pertinent at all to this argument, whether or not he's being questioned by state actors or whether he's on the phone with his family?
Well, I think that what you're getting to is the issue of state action, because just the fact that somebody deteriorates and says things in and of itself isn't the problem. The problem has to be that the state has created the conditions to cause that or exploited that in some kind of bad faith way, and so that's where I think they are in a good position, I think, by just pointing out number one, the total control that DOC had over his conditions and the knowledge that they have that this was a fragile person. They were on notice that he began to deteriorate, and so these things all speak to the fact that if they weren't deliberately trying to make it happen,
Right.
they at least weren't really troubling themselves that it was, and it was potentially kind of foreseeable that this would end up where it did. But also, I think that gets to their argument about the iPass settlement and what a critical role that plays, because it shows the DOC deliberately violating their own policies that they had been sued over in the Eighth Amendment context, as creating cruel and unusual punishment for people that are being subjected to conditions like this. And so that really, I think, speaks a lot to the callous disregard for the effect that these conditions were going to have on him, as well as their knowledge of
Right.
the very not unlikely consequence that exactly what happened was going to happen, that he was going to become psychologically broken. And so then to exploit that is what really becomes the issue in this context. Like, it's bad enough that you did it, but now
Right.
you're going to advantage your position in a criminal prosecution based on those decisions. At some point, you reach the shocks the conscience standard with the court, and
Right.
I feel like that's what a lot of this section is really geared towards, because there's not a lot of law on this. The law isn't necessarily all that favorable to them, but holy crap, if these facts don't shock a judge's conscience, I'm not sure that anything will.
Right. If these aren't the facts to make you a holding that encompasses these things, then there's nothing that would. Because as I after having Michael on and thinking of it from that perspective, I rethought my stance on it, and I do think you could argue like the unconditional conditions, the unconstitutional conditions of the jail, solitary, lack of sleep, lack of light, hygiene issues were it, even and that's if interrogation needs to be considered, but the functional equivalent of interrogation designed to elicit a statement or to break his silence. That there is enough facts here to say these conditions, this treatment, it seems the functional equivalent of trying to get him to break his silence,
Mhm.
designed for that,
Yeah, I
or
mean, I think that makes sense. You have you have, like, in the Fifth Amendment context, for example, the case law when you're talking about the right to silence or the right to invoke. Uh, Whether it's a custodial interrogation, interrogation is not just words or conduct intended to elicit an incriminating response. And so you could potentially look at this entire pattern of conduct, given the record of what they knew the risks were, what they knew about what their legal obligations, in this situation were, and choosing to disregard that anyway could potentially raise that type of question about, is this conduct that was at least anticipated? That it would get him to break and potentially say something.
right, and the fact that he, maintained his innocence beforehand, and I think he either invoked counsel or his right to not speak at some point during those, like, I'm not talking anymore, like,
Hmm.
I'm done, you know,
Hmm.
that should weigh in his favor in that argument, and then you also have, like, the totality of the circumstances, which you've got his mental state so degraded by the environment that state action caused, that he could no longer make, like, a free, rational choice, voluntary choice to remain silent,
Hmm.
so I think that the arguments they have in this section, bodes well for that kind of, interpretation as well. Like, I think they've said enough to say, without saying the words, that it, because I don't know that they say that it overcame his right to remain silent, and,
Hmm.
like, but I think there's enough there to encompass that. Do you think there's enough there to encompass that kind of
Well, I
specific?
think it hints at it. I mean, they're not making a Fifth Amendment argument, really. They're making much more of just a due process, yeah, shocks the conscience type of argument to it, and grounding it in the voluntariness. Um, I think the challenge that they have with this particular issue, the part of it that's always just been one of the worst facts in all of it for me is the way that they exploited it was they exploited it through his mental health professional, through his psychologist. You put him in a condition where he has these vulnerabilities, he has them. He deteriorates. He's got no other way to try to hold on to his sanity. This is like all you've given him are these, weekly meetings or whatever it is with Dr. Walla, and then to exploit those conversations that he had with her and turn those against him and use that in his criminal trial. To me, that's just it's just I don't even know how to explain like the horror and the offense that I take to that. It's just so Banana Republic level. I expect to see this type of thing in like Venezuela.
Right.
I don't expect to see this type of thing in a US court. The problem with it, though, is that that is the same thing that, from my perspective, is also making this argument probably the weakest one in their brief, which is that the finding of the conclusion of the statement being voluntary or involuntary depends on the facts that have been found to support that conclusion, the facts about the context, the facts about his deterioration, and all of that stuff. And that's where we're once again in a problematic situation on appeal, where we have this extremely unfavorable standard of review, where Judge Gold gets to find the facts, and she can point, as long as there's something in the record that supports her decision, no matter how
Tenuous.
Yeah, tenuous and just obviously bullshit it is. Like, I'm
Right?
sorry, but this whole learned witness crap in Indiana, it's absolutely insane to me that you get to put a prison guard on the stand as a psych expert just because, for no other reason than because you really want to. You really want him to be able to say the stuff that he's clearly not qualified to say. But
Right, but
once
then
that's in
keep
the
out
record,
the IDOC or the IPAS stuff that shows that they knew these
yeah.
conditions cause these issues.
Yeah, exactly, exactly. So it's very, very self-serving, that whole context. But so the problem is that now that that's in the record, I mean, they've said it, and we already know Judge Gold is found. He was fine. He was, probably faking. He was treated better than the people at Westville, everyone else at Westville anyway. It's so difficult to overcome that factual determination. And so I think the defense has done the best job that they can here by really focusing on, Polly Westcott and the analysis that she did, the fact she used these objective measures to test for malingering, to see if he was really faking it or not, pointing out the inconsistencies, not just between like Walla and Martin about like when exactly is he psychotic and stuff like that, but also just the internal consistencies between what they're describing, what like Dr. Walla is putting in her notes, and then what you can see with your eyes on the videos of him in custody on these different dates. But the problem is anytime you have conflicting facts, the judge pretty much gets to resolve them however they want, and that doesn't put you in a good position on appeal to be able to argue, the facts should have been found otherwise. So unfortunately, I think it's a very compelling argument, and I think it's important for them to make. And I think they clearly want to win this one. They have devoted a lot of time and effort to this particular issue and in finding the different frameworks. They brief it separately under the Indiana Constitution. But their problem here is just that fundamental resolution of the facts is not a good position to be in on appeal. And that's going to make this one a very hard one to win.
Yeah, and, I made this point with Michael. The court, and I don't know if you touched on this in your analysis of everything, but with the motion to suppress these statements, the court reasoned, and I'm looking at the brief now, the court reasoned the statements were voluntary because Allen failed to show. I might as well just stick it up here. Allen failed to show that they resulted from state psychological coercion or coercive interrogation. And I'm like,
Mhm.
she made a mistake. That's not the law. It's not
Mhm.
Allen's burden to show that they were
Yes,
voluntary. It's the state's burden to show, I mean, that they were involuntary. It's the state's burden to show that they were voluntary. She also touched on the court found Allen's detention was intended to protect him while he while he suffered from a major depressive disorder and anxiety, he did not have an SMI that would render his statements involuntary. Well, we also talked about what they intended by the detention isn't part of the proper factual thing for her to consider. It's what was the impact of the
sure.
detention.
Yeah.
So the fact that she made a mistake of law here and
Mhm.
possibly a mistake of fact with this, that he did not have an SMI. I don't know if she's saying, because Michael took that to mean she was saying she did not have an SMI, that he did not have an SMI. He might have actually changed that because I think we went back and looked at how they did acknowledge that MDD is an SMI, but that would render his statements involuntary. That could be another factual mistake, but this especially the burden, but her
Mhm.
making these legal errors, do you agree that those would, strengthen the possible success of this argument? Or what do
Well,
you
yeah,
think
I,
about
I
that?
think you make an excellent point that this is burden shifting, right? This is classic legal error where it's the state's burden to prove this. You have apparently applied a wrong burden, and so that might be another one of these situations where a way that the appellate court can kind of resolve that is to kick it back and say, you need to think about this again. You need to apply the correct legal standard, and you need to, make factual findings that show whether that is supported or not.
And then
Now,
are
the
we back at the
question.
same problem you mentioned earlier? That
Well, we're back at the same problem that we had earlier, which is, it's inherent on appeal. It's going to be kind of an ongoing issue, because the reality is, even if we get a new trial, the trial is still going to be in Judge Gold's courtroom, So that's an issue that is going to be omnipresent. But part of the concern again is, okay, what exactly do these statements mean? Are we saying that his major depressive disorder doesn't constitute a serious mental illness? That's going to depend on this IPAS report and the decision on the IPAS report, whether that needed to come into evidence or not, because that was the basis for that decision that major depressive disorder constitutes a serious
right here.
illness.
Right. SMI includes delusional disorder, psychotic disorder, and MDD, major depressive
So
disorder.
I looked at the because I don't know what they didn't tell us in the brief, what the specific, I guess, basis was for not considering the IPAS settlement, other than it was not relevant, or something like that. I remember when they wanted to bring it in at trial, but as far as in the context of the hearing, I'm really not sure. So the only thing I could think of was, well, hearsay. I mean, it is an out of court statement, right? That's offered for the truth of what it says. But it seems to fit within a hearsay exception that Indiana recognizes for public records, that include records of adjudicative proceedings by, bodies that have the authority to engage in that kind of fact finding. So, as irrelevant. Okay.
Right.
So yeah, that's another
absurd.
That's another fairly decent legal issue that that can be worked on, because relevance, of course, is also a very low bar.
And I think said this was one, to say this was not relevant was one of those, I want to bang my head against something and be like, you're not a judge. You have
it's up there with no nexus.
Right. This is not real. I'm in the matrix. A judge cannot possibly say their knowledge that the very conditions at issue caused the very symptoms that we're saying this man suffered is irrelevant. It's
yeah. And so, I mean, I take your point very, very well. And I think you make some excellent points on some of the legal deficiencies that are in her reasoning. The problem, though, again, is going to come back to the factual basis for it, and whether just either in the way that it's already written, where because of this factual dispute, basically, is he really crazy or is he not? Is he faking it? At what times exactly is he psychotic? Does the Haldol help or not? I mean, all of these kind of complicating things that we're expecting her to resolve. Is there a risk that the Court of Appeals is either going to read into what she already wrote, that there's no psychological coercion here, as being grounded in a certain view of those facts? Or if they send it back to her and say, fix it, is she just going to, make it explicit? Well, he was faking or whatever.
Right. Her credibility determination of but on those, they can see those videos themselves. So they might be able to make some of their own credibility determinations, unlike where they didn't get to see how, someone testified. They're getting to see what his behavior was. And my biggest thing with these, and I don't know how, and I'm just going to skip to it because, we've got obviously the IPAS thing and whether that was relevant. We just talked about that. Then they talk about you've got the audio from the, from the videos of what's going on, which, I think are important. But to me, and I think you might have said this was, I don't know if it was what you thought was not their strongest argument, but those damn phone calls, when you hear the phone calls in context, how you can say that that's not, and I'm jumping ahead because that's more of an evidentiary issue, So maybe
Well,
I
let's get to this third one, because I don't know about you, but this whole broad, deprivation of the right to present a defense, as broken down into these little kind of sub issues, all of these different instances where that took place. To me, this is the strongest argument that he has, and I think this is the one that's most likely to get him some kind of meaningful relief, like a new trial, because it is so fundamental to just the basic functioning of the trial process. If you can't use your hands, it's not going to be a fair fight in the ring.
right.
Um, and so it's a way of kind of taking some of these issues that are, yes, they're evidentiary rulings, but if you can show they're wrong, and several of these, they have an excellent argument that these are just
Yep.
flat out wrong rulings. But also, just the way that fit in the context of this whole story, in terms of what the jury did get to hear and then what the jury didn't get to hear. I think it's a very powerful, and it's the clearest pathway to give the court, also potentially the most appealing pathway to give the court, to correct an injustice here.
Right.
That, look, this what we did before did not work. You can't rely on it. It was inherently dishonest and problematic from the outset. So send it back and let us put all of this in context and then see what happens.
Right. And your first one is the reversible error by excluding Blair's sketch of Bridge Guy, so
Hmm.
that the trial court, excluded the sketch. So
Hmm.
on that, what are your thoughts about how the court might interpret or feel about
This
that?
particular one, I didn't think the law, it didn't seem like the law was really all that strong in its favor.
Because the description kind of really helps. They have that at least.
Well, and I think, yeah, there's you have a problem with establishing that it's a legal error in the first place, and then even if you do, was this just kind of cumulative of what she was already allowed to say about what Bridge Guy looked like, and her description we already know doesn't match Richard Allen. So is this really adding something game changing to the trial calculation? I'm not real sure about that one. I think, they would have been in a stronger position here had somebody asked Betsy Blair, that guy sitting there at the table there, is he Bridge Guy? Because then if she says yes, you're in a much stronger position to be able to impeach
Impeach
her
her.
with this 10 out of 10, accurate drawing that she adopted. Um, but nobody did that. And so, just standing on its own, I'm not sure that this particular issue is going to be a big game changer.
So from the constitutional argument they make that it interfered with their ability to properly cross-examine her, and for instance, you just said, and now I don't recall, and maybe I should check real quick, if they were able to ask her, did you make a sketch, and did you find that sketch to be, uh, 10 out of 10? Um
Nope, they couldn't touch the sketch. Nothing about the sketch.
Okay, so then if they weren't able to ask her about, you gave it a 10 out of 10, you gave it a 9 out of 10, does that not, um, you know, uh, isn't that something that would have been important in cross-examination to go to, how strongly she felt about it?
I don't think so, because you're not really crossing her on that. You're kind of bolstering what she already said on her direct, which was just that, the description is a young man in his 20s, beautiful, tall, poofy hair, all of those things. So we already kind of know it doesn't look like Richard Allen. This is just substantiating that. It's not really contradicting it.
So then if they would have asked the question, "Is it him?" and she said yes, then you think that 10 out of 10 now becomes
Absolutely. Now I think you're in a position where she has adopted this already. She's, described it, somebody drew it, she said this is accurate. And so that's impeachment. I think at that point you get to bring it in. Now I think it's unlikely she would have said yes, but we'll never know because nobody asked.
right, right. Okay, so then um the the next thing that they said was excluding Tobin's testimony. Now, I
Mhm.
can't recall how much now I definitely see these that Tobin would have put in completely different testimony because he's saying
Mhm.
the whole ballistics thing is bullshit. It's so messed up. It's too subjective. Da 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 da. So he would have put in other evidence, but is it possible for the court to say, and I don't remember what the other expert said. I know
Mhm.
he obviously challenged her findings, and did he get a chance to say that, and by the way, this whole science has come into question? By the way, like, was there any of that with the expert they did get on?
So, I mean, kind of. Warren did acknowledge that there are criticisms about this methodology. He was different than from Tobin, where Tobin was flat out like, "This is junk science, shouldn't be allowed." Warren's like, "Well, it could be improved," and so he testified about things like there are kind of other standards that you can apply that would be more objective. These things that are kind of in the works in the community, in the toolmark community, to try to make things a little bit more objective and less this circular standard. So I think there is a distinction, between the critique that Tobin was going to bring that was far more systemic than the critique that Warren provided. But they are similar and they are related, and I think because of that, this is another one where it's just not entirely clear that had they been able to bring this particular criticism, was it really significantly adding to what they were already allowed to do? They were already allowed to say this is a subjective standard. They were already allowed to say there were problems with how she did it. They were already allowed to say that it's apples to oranges, trying to compare a spent shell casing to an unfired cartridge. Um, Without seeing like Tobin's declaration or offer of proof or anything like that, it might be a little bit hard to say exactly, what he would add. So it's hard to evaluate this one a little bit, but that's the risk I guess I would be concerned about, is just that the court would be like, well, you already got to say a lot of this stuff anyway. So is he really adding something that is so different and so game changing that, it would change the verdict?
So that raises a good question. Do you recall if the defense asked or made an offer of proof as to what he would have testified had he been called? Because that could have an impact on an appeal.
Mhm. I don't recall offhand. I remember very specifically the oral offer of proof that they made at the end of the trial, where they brought up the third party culprit stuff. I don't remember specifically if Tobin came up during that. I have to
And
think it would have, because surely the appellate attorneys would know if it's not preserved.
right.
Um, Maybe
I
save your
that was
fire on that
another
one.
kind of thing. I was like, a lot of times they're not telling us how this issue, like, I'm used to reading that in a brief, like, this issue was preserved, the defense argued X, Y, and Z. And there's some of that we don't see, some of it we do.
Mhm.
But and I know
Mhm.
Bob's out there. I just put up his 2 of his comments. I don't know if you remember, Babe, if they made an offer of proof. But one of the other things I was gonna ask, if Andrea or you, Babe, out there in the background, know, pretrial, did this defense attempt to, and I thought they did, exclude the state's ballistic expert because her findings were unreliable because she compared apples to oranges?
I think it was. There were like competing motions in limine on this, where they wanted to throw hers out as unreliable, and the judge is like, that's for the jury to sort out. And then the state wanted to throw out Tobin, or one of them is like cumulative, or something like that. And that's my recollection of it, is she's like, these guys are basically the same thing, and so you don't get to present them both. She said that metallurgy like wasn't, maybe that was part of it too, that metallurgy like wasn't relevant, again, like it wasn't, he wasn't qualified to give the opinion that he was being proffered to give. So that, again, we're in kind of a situation where her legal reasoning seems probably a bit tenuous, a bit dubious, because there's all kinds of ways where I can see metallurgy being, kind of important when you're talking about the marks that metals leave on other metals under different conditions. But it just comes down to the specific facts in this case. Had he been able to testify, what was he going to say? And was it so materially different from what Warren had to say that it was potentially, outcome determinative?
And hopefully that doesn't fall in the defense for failing to make an offer of proof, but maybe there was some in a pretrial hearing that's going to, cover that. But what she did say, at least according to the brief, is the judge excluded him because he's not a firearms expert. He was untrained in firearm identification. He did not examine the evidence in the case, and he did not conduct a firearms examination. According to the court, Tobin's testimony does not go to an issue before the jury, and like you said, lacks relevance. This decision, and then they said, violated his right to present a defense. And it's like maybe those reasonings that the judge gave will again help make an issue get over a hurdle here, because it's I think an abuse of discretion. But again, this court can't determine it unless they have an offer of proof as to what this guy was going to say. And we at least don't see that here. Maybe one of the things that they cited goes to that. But what I also don't see here, unless I'm wrong, is that the judge erred in not excluding her evidence. I do think as a gatekeeping role, when you have apples and oranges, this is so clearly apples to oranges. And for those of you out there who might not know exactly what we're talking about, you have an ejected, and maybe you know more about firearms to talk about it, but an ejected casing. So it didn't go through the gun. It was ejected by racking the gun. This witness, this expert for the state, multiple times attempted to get the same markings by simply racking the gun, apples to apples. She could not. That should end the scientific question right there. She goes on to then fire the gun and now tell the jury, the court, that, oh, I found a match from my apple of an unfired, simply ejected casing, which I mean, that's the biggest part. And I tried to recreate it in the same conditions. I tried and could not after multiple attempts. So I did a step further and fired it, and now compare my orange to my apple. I do think that was an error by the judge. I do think that's what her gatekeeping function is. And I would have liked to see, unless I'm forgetting, and it's next one of the arguments here, that the court erred in allowing her testimony in.
Yeah, they did not raise that argument. And this is another one where it probably just goes to the fact that there's a dispute. Melissa Oberg is an expert and she says it's just fine, right? And so if she says it's just fine, then that's, potentially enough for the court to hang its hat on to say it's perfectly good science. I do not expect much from the courts anymore in terms of excluding junk science. They should, but you will just never, you'll never be disappointed if you just expect they're going to let whatever horse shit in that somebody, with a credential wants to be able to say.
So you think even if this issue was raised to the appellate court, and to me, common sense, without anything else, says you're looking at apples and oranges. They tried to recreate it under the same conditions and couldn't. This was bullshit. It should not have gotten in. You don't think that an appellate court would have taken that step just under the law, that it would have been?
I think if the appellate court was conducting its own Fry hearing or Daubert hearing or whatever hearing on admissibility, it might very well reach that decision, but it's not. That's the problem, is that we're in the appellate context. They don't want to be the decider. And So they are just once again in the standpoint where they defer to a lot of the discretion that the trial court has to be able to make those types of judgments. So I think it's going to be enough, more than likely, that that Melissa Oberg says, "Oh yes, it's totally fine to do this. It's not really apples to oranges. It's not really that big of a deal, to make this different type of comparison." And the idea is that the jury is supposed to hear both sides and sort it out.
All right. So their next issue, which I'm assuming that we both agree is like the one of the strongest issues, the Google search by Cecil. So the this falls under the court committed reversible error in admitting
Mhm,
hearsay, and that hearsay
mhm.
was the officer's Google search of whether or not moisture or dirt can clog the component of a cell phone enough the to give the and this is the craziest part, not only to trigger like an issue with the headphones, but to tell Cellbrite it's to make Cellbrite flag it as such that Google says that that's a possibility from just dirt and water, and that
Mhm.
overcomes everything. Um, I'm assuming you agree that that's one of the strongest issues here.
It's obviously hearsay. Like, there's no question about this. This is classic hearsay, to the extent that I have literally won an appeal on this exact issue. Some witness Googles some crap and then presents it as substantive evidence. You're not allowed to consider that. Actually, I did. I got a girl's felony conviction. Conversed on ineffective assistance of counsel because the trial attorney did not object to this horseshit, where a guy's like, "I'm googling the price, the market price of whatever type of used computer it was, and comes up with the number that just happens to be over the threshold in Washington for a crime, a
Okay.
theft crime, to be charged as a felony." So the court agrees, yes, this is clearly hearsay. It's clearly being offered for its truth. There's no other evidence of value in here. It doesn't meet the standards for admissibility, so there's no reason not to object to it. It gets kicked back down, and you can either have her convicted of the misdemeanor or retry it. So this one is classic. This one, solid on the law, in my opinion. Where this starts to get interesting at this point is how the court decides that it's going to look at the effect of these errors. And there's a couple of different ways that it can go. It can look at each of these issues in isolation, right? It could say, yes, we agree that this is hearsay, and we even maybe agree that she was legally incorrect in excluding Tobin's hearsay, or Tobin's testimony. Tobin's testimony was relevant. So there's these legal errors we can identify, but how are we going to evaluate their impact on the case? If we just take them all one by one and say, well, but if Cecil hadn't been able to testify about the Google search, is that really going to change the whole dynamic? If Tobin is allowed to testify, is that really going to change the whole dynamic? Or you can take all of these possible errors, assuming that we find multiple, and I think there's grounds here to find multiple evidentiary errors like this. Then do we look at that as a cumulative? When you look at the total impact of everything he wasn't allowed to do, in light of what the state was, and the kind of false impression that then created with the jury about the strength of the case, you're in a little bit of a different mind frame, not just when it comes to is this going to be reversible at all, but also what's going to happen when it gets sent back down. If you kind of nitpick at each one individually, you're kind of saying no harm, no foul. So if the judge does it again, it's not really any big deal. But if you point out there's legal error, there's legal error, there's legal error, there's legal error, and taken collectively, all of this deprived him of a fair trial, there's a much greater chance that when it goes back down, all those things that you've said are legal errors need to be corrected the second time around. So I'm going to be very intrigued to see how some of this goes, because I really do think that they have very strong arguments on the legal footing for a lot of these evidentiary issues. It's just going to be a question of what's the impact that the court assigns to those. How significant does the court think they were in the grand scheme of things? And they have a little bit of power to kind of decide the path that the case is going to take based on how they choose to look at the effect of the different errors.
So, and speaking of cumulative error, when I
Mhm,
started to read this and got through the beginning and saw no separate cumulative error issue, I control F cumulative. It's nowhere. Do you
mhm.
think that that is a huge issue?
I don't. I mean, it's not really a separate assignment of error. It can be like you can write it like that, but I don't think you're really required to. The point is just that it's the effect of all of these other things. Sometimes, so Washington has a cumulative error doctrine that says even all of these things, if they're error, standing alone would not necessarily constitute grounds for reversal when taken collectively. The impact requires it. And so it certainly fits within this type of framework. And I think you can present it like that. But you're not precluded from arguing, that the effects of this are substantial, that the effects serve to undermine his right to a fair trial. Just because you haven't specifically, you use the magic words cumulative error or anything like that. So I think they're going to be fine there.
All right, because in Illinois, to rely on the cumulative error doctrine, you generally need to raise it like as a distinct
Mhm.
argument in your appeal. At
Mhm.
least that, and maybe it's the cases I'm reading. I haven't like separately looked at it for a while. But it frightened me when I first
Mhm.
read the brief. There are some sub issues. Um, for example, the next one after Cecil is the court committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. And they specifically say the judge made three reversible errors.
Mhm.
Together, the decisions violated his constitutional right to present a defense. So here, there was a couple of them where they used words like together or
Mhm.
individually or together. Um,
Mhm.
and I just wanted to make sure before we moved on to that, was there anything else on the Cecil
Ju
issue?
just to kind of speak to that, I think that, what might help them in that regard too is the fact that they have the way that they've organized their brief, they have kind of collected all of these different errors under the single harm of, not being able to present a complete defense.
That's true.
And so, I think if you look at the assignment of error in that broad picture, then that's what you would be looking at the implications of any individual error that you find in that regard. How is that contributing to this problem that's been identified of the inability to present a defense? So it might be kind of like a workaround where you're not specifically saying cumulative error, but you're pointing to the effect of all of these things on the
Under one
ultimate
issue.
fairness, and so you kind of have to take it globally.
Yeah, that's a good point, at least for for section 3. Sorry. Sorry about that. I want
No
to because,
worries.
like, I got completely over my cold and then got a new cough just in time for my granddaughter to come over again.
It's
It's
this time of year anyway where the entire house is like, 10% humidity or whatever because all the heat's on and
right,
and
right.
stuff.
But your point's well taken. Under issue 3, the court denied Allen's right to present a complete defense to explain the scene and impeach the investigation. All of these things are sub-issues under that one category, so that might
Mhm,
save and be, like an implicit cumulative argument issue.
mhm.
Um, and before we jump to the confessions, was there anything else about Cecil that you wanted to say before we
I just the it was fun to read this section of the brief because of how dripping with contempt it is. I mean, the use of the irony quotes, uh, it's just one of those things where, y y I know attorneys a lot of times have to have a very dark sense of humor. And so they laugh their asses off about this. I mean, it's
Yeah.
just so ridiculous. It's so embarrassing for this guy. So to be able to kind of dunk on it like they did, it was, I'm sure, a fun moment for them, a little bit of light in the midst of all of this darkness.
Yeah, for sure. For sure. Okay, so the next issue that they raise in this or sub issue, that the court
Mhm,
committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. Now, so
mhm,
this is the one to me that I think should win. I hope wins. And it's, to me, the easiest way to say it was that they deprived the jury of the ability to weigh the reliability and credibility of the confessions.
mhm,
And especially, like I said, with the book ended phone calls. So,
mhm,
but before we get to the book-ended phone calls, the first one they
mhm.
touch on is the audio from the solitary confinement videos. How strong do you think the exclusion of the audio goes in considering this whole, issue about whether they were denied the ability to judge, the credibility?
Yeah, this is another one where I think they're on very solid legal grounds because there's no question this was not offered for a hearsay purpose. This wasn't offered to prove that what he was saying was true. This was offered to show his state of mind and the condition that he was in at the time that he was making all of these statements. So the exclusion is just flat out predicated on an incorrect
Right.
interpretation of the hearsay
This is
rule.
another one where I wanna bang my head against something
Mhm.
and be like, "You're not real. You're not a judge who's made the." It's like, you understand hearsay. We all know you understand hearsay, and
Yeah.
clearly, none of this is being offered for the truth of the matter asserted, so you don't get past that she knows the definition of hearsay. It's an
Yeah.
out-of-court statement offered for the truth of the matter asserted. This is
Mhm.
non-hearsay.
Mhm.
It's black and white non-hearsay.
Mhm. Yeah, so it's one where again I think they're on very solid legal footing. The question is, what's the effect of it, and is
Right,
the effect of it going to be considered in isolation? Because once again, we do have some other context of what was going on. We have the notes from Dr. Walla, we have the notes from the suicide companions and everybody else. We had kind of testimony about a lot of these different events. And so, if this is just considered in isolation, well, is that cumulative of what the jury kind of already got to hear? Possibly. But if you look at this in the context of how it contributes to this sub issue as a whole,
right,
does it relate to the jury's ability to evaluate, should we believe this confession or not? If an hour earlier, he was like catatonic and drooling in the barber shop, then that might kind of matter. That might be
right.
pretty pertinent.
Right. No, agreed. And that's why I think I keep my like strongest one I keep pulling towards is the phone calls because of what you just said. Like this is an
Mhm,
obviously legally, no question about it. The
mhm,
the, the appellate court says you made the wrong. I would hope so. I mean,
mhm,
I'm gonna have to like re-go to law school, but that legally this was non-hearsay and
mhm,
but question is that alone enough to say it would have made a difference? And like you're saying, I think together for sure. But when you look at two, their
mhm,
next error under this issue is the court committed reversible error in prohibiting the jury from hearing two phone calls Allen made on April 3rd. And
mhm,
this to me has both things. It has firm legal footing and unquestionably, undoubtedly would have helped the jury determine whether or not what was said in the middle is credible, is reliable, was a free,
mhm.
a statement of a rational person who was actually admitting to something.
Yeah. The weight that you should give to that middle part, is very different when you don't understand the context that it was presented in. This one to me, so I thought that actually this one of the 3 of these sub issues, I thought this one was probably on the weakest legal footing, and I'll tell you why, just because I think there's certainly a reading of it that, just like the first statements, it's not hearsay. It's not offered for a hearsay purpose. It's there to prove his state of mind. But I think there is a much stronger counter argument that they are, in fact, offering these ones for the truth, because the truth is he thinks he's going crazy. The truth is he doesn't remember what he just said. The defense wants the jury to believe those things that he said in those bookended phone calls.
But
So,
but what about an exception to hearsay? So
well, yeah, that's what I think we get into, because they had offered it under the rule of completeness. And the rule of completeness is, it's any part of the statement that needs to be considered in fairness in order to put the statement in context should be allowed to be presented. And so Judge Gold got around that by basically just interpreting the statement in such a limited way that it was like just this one particular phone call. That's the only statement. And so the other two, bookended ones don't really count. But the rule itself doesn't seem to contemplate that. It seems to contemplate a much broader potential interpretation, where not just necessarily the statement, but like other documents, related statement, things, just whatever is
other
necessary to be able
statements
to
that
put it in.
put it in context.
Yeah,
But this
whatever is
was another
necessary
one,
to
Andrea, that when
put it
I
in
got it,
context.
I control F for the words completeness. They don't
Yeah.
mention the completeness doctrine at all,
Yeah.
which
No, they didn't bring it up here. And so that gets to a little bit of a point too that I've thought about with a lot of these different issues. And we'll definitely get to it when we get to the nexus that's also never mentioned. But it does make me wonder if some part of their argument they're kind of holding in the bag until it's time for the reply. Let the state go ahead and make the argument that this was the justification for the reversal, and then we can come back and explain why that isn't
that doesn't work.
appropriate either.
Right.
So I think that's possible.
So
But yeah.
I hear what you're saying about it's being offered for the truth, so it's hearsay. But one of
Mhm,
the exceptions to hearsay, in addition to the completeness doctrine, which I fully agree was
mhm,
absolutely an exception that should have been applied, would be it goes to state of mind, and even true statements can be used to go to
mhm,
state of mind. So that's why I
mhm,
think, legally speaking, it falls into that exception as well. And
mhm,
maybe I'm being overly helpful in that regard, because and there's also the whole, when the Constitution requires, a way to get around hearsay, and I just can't see any world where those two calls are not necessary and crucial to the
mhm.
jury's determination of the reliability and credibility of those statements.
Yeah. No, we're in total agreement on that. I mean, the fact that it was taken so out of context. The other part of it too that we haven't mentioned is the way that Harshman was allowed to misrepresent it.
Right.
And so, if nothing else, that's another non-hearsay purpose to be able to bring these in, is to be able to impeach Harshman with his claim that, oh, everything seemed fine. Oh, really? So when he was, calling his dad an hour before, saying he thinks he's losing his mind, is that something that you considered when you say he was totally fine and not under any kind of duress, and so forth?
Right, and
So a
then their
lot of.
answer is, "Oh, but we think all of these calls were just like a play. He said that on purpose first because he
Yeah.
knew he was gonna confess next, and then he pretended he didn't know he confessed it. That was all a game, and again, I'm going to ignore everything I know from that iPass, settlement."
Yeah.
You
Yeah.
know? But, um, to me, I just feel like those needed to be in, and I wish there was some more law. There's, like, no law in that little section
Mhm,
alone, although they
mhm.
they laid some law out, above that, but a jury has to be able to, judge. It's the whole reason for the completeness doctrine is to
Mhm.
put something in context so that somebody can make a determination on whether to believe it or not,
Yeah.
so I don't
Yeah,
know.
it's just literally you're not supposed to be able to cherry pick, and this is classic cherry picking.
Yep. All right, so then the third one was the trial court erred by excluding the statements and behaviors that provided the foundation for Dr. Gracian's opinion that Allen confessions were not credible. And I think
Mhm.
that did the judge here say that that it was hearsay? Because you can't have experts are allowed to rely on hearsay if it's something an expert typically relies on, and a
Yes.
psychologist that's what was Dr. Grassian a psychiatrist, psychologist?
Yeah, he was a psychiatrist, I believe, maybe a psychologist, I forget, but he
Okay,
was the academic expert in the effects of solitary confinement, and he also gave quite a bit of testimony about the characteristics of false confessions. He's the one that told us, they start as an idea, and the person kind of flirts with them with the idea a little bit before they kind of start to turn that into something more material that they hold on to. So I think I did it. Maybe I did do it. Stuff like that. The things that were like verbatim to what was coming out of Richard Allen's mouth.
so this one's super strong, I think, right, on
Yeah.
the law that this should have been allowed in,
Yeah,
and
it should have come in as the basis of his opinion because it's the type of thing, yes, psychologists rely on what people say in order to make evaluations about their mental state. But I think it's also particularly strong from the
right,
factual standpoint
yep.
because there was no other evidence that the jury got to hear about the fact that he was confessing to things that didn't happen. He was confessing to false facts, and so how are they going to reasonably be able to evaluate if this is a believable confession or not if all they're hearing is, oh, he's confessing out of the blue to facts only the killer would know, and they don't hear the times that he confessed wrongly to things that never happened.
Right. This one's another huge one for me, that this has got to be undone. It was very, very just like I think the calls were important. All of this, what you just said, is crucial to the jury determining whether or not this is a credible, reliable statement.
Mhm.
And again, the legal ruling being just so wrong, that I hope that I'll be shocked if the appellate court doesn't find this to be an erroneous ruling by the judge.
Yeah.
I don't know that they told us in here. Was it hearsay? Was it the judge
They didn't
prohibited?
say, but my recollection, maybe I was just projecting at the time because I was so used to what Goal was doing by that point, but my recollection was it was self-serving hearsay.
Okay.
Self-serving hearsay.
Right, and they write here, "This was reversible error. First, Allen's false statements were not hearsay." So I guess we should assume she
Mhm.
decided that they
That they
were
were.
hearsay. Right, and then
Yeah.
they go on to give the very applicable, exceptions. So and
Mhm.
then I can't imagine here, and I can imagine why you think is this that this is one of the strongest is because you really do have both things here. The law is black and white,
Mhm.
and you can't say that there was no prejudice from the fact that this didn't get in.
Mhm.
It's super important
Mhm.
as far as giving context and impeaching it.
Yeah, absolutely.
So overall, either individually or taking the 3 of these, do you think that this is an issue, alone now, just not in conjunction with all the other things under 3, but this
Mhm.
issue alone, but all of the ones that make up the phone call, the, the audio, the stuff to impeach the credibility of Allen's confessions. Do you
Mhm.
think that this has legs enough to win on its own?
I do. I think, even if this was the only thing that they won on, and I don't think it is likely to be, uh, to me, I think this is likely, enough to get him a new trial because of how important the confessions are. It's, the strongest evidence they have because otherwise, he's not there. There's no physical evidence. There's no eyewitness. There's nothing else really to substantiate it. And so his own words, if those are undermined, then you're just in a much weaker position on guilt than if you have this confession presented in a way that the jury is going to be inclined to accept it because it looks believable.
Right, which goes back to what we discussed early on, because now we're dealing with evidentiary rulings, so harmless error is in play. give them all the facts so the court can say that this was harmful because the case is relatively weak, or like you said, this is the strongest, one of the strongest pieces of evidence they have.
Yes.
And then Sherry DV lets me know that throat coat is en route per Bob. All right, thanks. Oh, and so close to 60K subs. Yes, we're like 50 away or like 40 away. It's crazy. We've been trying to get to
Nice.
60 for forever. So, but thanks for letting me know that. And thank you, babe, for doing it. So, um, okay, so then those were the 3 for that. And then the next part is the all right, the motion to correct errors. So I just don't know with the one of the biggest things being the the white van, what time it came in, what time it came out, if this couldn't end up being an ineffective assistance of counsel argument later, but the state did elicit it. Is that
Mhm.
going to be enough to say it doesn't matter what the defense knew or didn't know? The state elicited this and they knew it was misleading? Or do you question whether this raises enough to say they actually knew?
Yeah, I think that's the challenge on this is the record to prove what they actually knew, because you're once again in a situation where there's conflicting evidence, and not just conflicting evidence between what's said and what's on, what the timestamps on the video and things like that. But also just the, fact that Brad Weber was all over the place with his statements, even from day one. Uh you have such a high hurdle to clear to convince the court that a prosecutor has knowingly committed, suborned perjury. That's really what they're saying. He knowingly suborned perjury. You have to be on real solid ground, both in establishing that the information that was testified to was false, and that the prosecutor knew that it was false, not just that the prosecutor thought, this was one possible resolution of competing evidence. And I just don't feel like we have enough of a record here to be able to say that definitively. There's ways to explain around, the apparent inconsistencies. I do feel like this has always fit a lot better in the ineffective assistance of counsel framework, because of the fact that they did have it and they could have used it, and so they didn't. And had they brought that up, then maybe we would have answers to some questions like, are we sure the timestamps are accurate? And did he drive straight home? Did he pause the car, at any point along, like any possible way you can conceive of to reconcile what Brad Weber is saying that would put him under the bridge at the right time, with 40 minutes, 20 minutes later, whatever, ending up, connecting with the phone at his house.
So
You just
let me
really
ask you.
be able to exclude all of the other possibilities before the court is going to be willing to go down that road. And just because of the context here, I don't think we have that record.
So have you had occasion? So Glossip, it came down. I filed a supplement to a pending post conviction petition that I have, because Glossip did expand, sort of. It clarified and expand the application of NAPU. Is that how you say it? NAPU,
Napui,
NAPUI, in
Napui,
ways
I
that
think.
that remove, in some significant ways. Now, have you had occasion to actually read, like, analyze and apply Glossip at all?
So I haven't had a case that involves Glossip. I haven't had to like use it in that extent. I have read it, certainly. Um, I think, the issue that I remember seeing with both Glossip and with Napui is that they do involve pretty specific claims of fact that were easy to disprove. And I forget which was which, but one of them concerned the lack of any kind of prior offer, from the
I think
prosecutor. The
that might have been
prosecutors, it might have been
NAPUI, because
Napui.
right, because
Yeah, is
Glossip.
literally the one who's like in the best position to know that the prosecutor, made an offer to the defense.
But
And then
in
Gloss.
Glossip, there was a question, because it was like,
Uh-huh.
did he really lie, Or did the actual person testifying think that he didn't know about his own mental health? He didn't really
Uh-huh.
understand his own mental condition,
Yeah.
but that the
Yeah.
prosecution, they had enough information to know what he just told the jury was misleading, because it was like he said he wasn't delusional. And I should have read it probably before we came on, but it was something to the effect of like they
Mhm.
gave him some kind of medication for a cold that caused delusions, when no, he was like had some significant mental health issue that prompted
Yeah.
them giving him this
He had, like, a long
medication.
record. He'd been hospitalized or something.
Right, but the question there was like, was it really false testimony because the person speaking, the
Mhm.
he may not have understood his actual condition. So he may
Mhm.
have been telling the truth from his perspective. I don't know. So I just thought
Mhm.
gossip gives us a little room here that I
I mean, it
hope.
might, it might. I'm I you know, I'm kind of looking at this one just from,
Like you
I hate
said.
to say a legal realist standpoint because
Right.
that sounds so cynical, but like it kind of, it
Like you
is like there's a
yeah,
lot of
they
overlap
don't
between
like to
legal
find.
cynicism and legal realism. And I they're gonna bend over backwards
Right.
to not find that. So you really do have to have them boxed in to the point where it's undeniable. Um, that's the only way that you can really be sure on an issue like that. And I mean, they do. They have good facts, but is it, completely undeniable? I'm just not sure they're there.
Right, and this is the part that one of the things that the prosecutor said, if you take a look at the health app data, there is a
Mhm,
pause in the movement for 7 minutes. He has 7 minutes with them, but before he can finish his deed or his deeds, he sees a van, Brad Weber
mhm,
coming home from work down his private drive to his home, and he scares Richard Allen.
mhm.
Then Richard Allen forces the girls across the creek to a spot in the woods, a secluded spot, and he kills them and cuts their neck. So, it's like when you take their timing, it almost can't work no matter, like looking at it at all the different ways. Like if they didn't say, then he forced him, like they boxed themselves in right here
Mhm,
to this timing that he
mhm.
saw the van before he crossed the lake, and the van is the reason he crossed the lake. Then how can the phone data stop moving, being the last bit of movement, so much sooner? He
I
arrived
think
home 25 minutes after the pause in movement on LG's phone and nearly 15 minutes after LG's phone was on the other side of the creek. Thank you.
I think the way, that this becomes an issue is because we already have a little bit of discrepancy in the timeline here anyway. If his camera footage shows him coming home at 2:44, but it's not for another 6 minutes until, the phone registers. So we have this kind of internal like calling into the question, like how good is this timeline data anyway? And then we don't have an authentication of these timestamps.
Right.
That's part of the issue with it as well. So if we had any of that in the record and we had the ability to point to it and say, look, the prosecutor had reason to believe that these timestamps were accurate, that these measurements were appropriate, I think we're in a much stronger footing. But we don't have that in our record, and so that's where I think we haven't blocked them in to the point where there's no possible way that these things could be reconciled.
I hear you. The realist putting us in check. I mean,
I'm
it's
so
true.
black pilled.
Right, but it's legitimate that the courts do not want
Yeah.
to, you know, they don't want to say a prosecutor has engaged in misconduct, and it takes a lot to get there. We'll
Yeah,
just have
it
to
does.
see if maybe there's something you know, that that gets them there. Um, let's so harbinger of imminent death says, what are judges supposed to do if they just don't know how to rule mid-trial when a long adjournment be impractical? Phone a friend, wing it.
You shouldn't be mid-trial with an issue that would require a long adjournment for first off. Anything that's like so complicated that you need to take a whole bunch of time, to research it or whatever, it should have been brought up pre-trial. It should have been the type of thing that's fleshed out in limine. So I mean that's part of the answer to that. But things come up in trial, and that's part of your job as a judge is to figure out how best to deal with it. And so if you can't research it thoroughly, when you're on your breaks, you're not on the bench, when you're in the evening, I mean, whatever, everybody has to work a little bit extra hard during trial. If you're not in a position to make a ruling on it at the time, you better look it up and get as close as you can, so that if you're going to wing it, you're winging it at least from a position of being somewhat informed about the legal context that you're operating in.
Right, not just, completely ignoring everything we know a judge must know. So Amanda points out, and thanks, Amanda,
Mhm.
that Agent Paul was going to impeach Weber, no? And why is and should that have been raised, that agent was wrongfully excluded?
Yeah, that was an issue that was perfect personally, really aggravating, just because it was Gull being Gull. Andy Baldwin laid an absolute textbook foundation to come back and impeach Brad Weber with Agent Pohl's testimony. She said that he didn't. Literally, like there is literally a guide from the Indiana University, the Indiana Law School, about how to lay the foundation to impeach a witness with a prior inconsistent statement, and he followed it to the letter. The reason why I think they didn't bring this up is because at the end of the day, they were able to get that in. When Brad Weber was called back up the second time, Andy was able to ask him about these prior statements, and so he had the opportunity to explain them. So the fact that he made them was no longer something that he contradicted that would have justified bringing in a third party witness to impeach him. So I didn't like it because I didn't like that the state got to bring Brad Weber back on the stand and kind of rehabilitate him, because the first time he was on, it was a freaking train wreck. Like this guy is loony. He ends his testimony like freaking out. It was unnerving, the way that he presented. But they had time for somebody to sit down and have a little chat with him about how to behave, when you're a witness, and then call him back up and kind of fix some of the mistakes that he made before. So I didn't necessarily love how all of that played out, but just from a standpoint of, is there really an error at this point to be aggrieved about? There really wasn't. She let them cure it through this other way of bringing it in.
And that kind of goes back to what Andrea's been, raising a bunch of times, is that, the court can find it was an error. It was wrong to exclude Agent Pohl, but there's no uh, significant prejudice because, like Andrea just said, that information got to get in. But it might
Mhm.
have been nice would it even warrant mentioning here that, you don't even think it warranted words?
Um,
All
No,
right.
because it's getting nitpicky, and you've got limited space and you got to prioritize and stuff like that. It's in the grand scheme of things, one of the things you got to let go.
All right. Gotta let it go.
I hate
Oh,
it. I don't want to,
right.
but I think you gotta.
All right. So now the trial court committed reversible error when it excluded Allen's evidence explaining this murder as a ritual killing.
Mhm,
I like to change this and to say words like to explain that the killer or killers had knowledge of ritualistic, symbolism or Norse pagan symbolism. Like, I just don't think you need to call it explaining that it was a ritual killing, because to me, the scene indicates someone with knowledge of these things. The other
mhm,
thing, I don't know if it's in here, and I don't know, maybe I thought it could have gotten in here through the record of this and I bet it's in a Frank's motion somewhere, but that his devices showed no history ever of searching anything related to Norse paganism. There's,
mhm,
like that maybe they needed some facts here for that to show this guy isn't the guy that would
mhm.
have had knowledge of Norse paganism symbolism in order to make the scene look a certain way, whether it was truly a ritual or not.
Mhm.
But I think that so what do you think about this issue that they were not allowed to explain the scene?
Well, I think the fact that they weren't allowed to explain the scene is a big problem, because it's plainly relevant.
Right.
You know, what was done to the girls and why is pretty important in evaluating, who did it, what their motive was, and so forth. And so if this was a ritual killing, then yes, that calls into question, the motive that has been asserted by the state, that Richard Allen did this just kind of opportunistically, and it was kind of an ordinary, sex motivated crime. But otherwise, nothing really extraordinary about it, when it's highly unusual, it's highly strange. There's a lot of weird stuff going on with it. And so to not be able to provide a competing explanation for why it looked the way it did, why things were done the way that they were, puts him at a significant disadvantage, because you're just left with the state's explanation of this is what happened. And even if that seems highly improbable, you can look at it and think that doesn't look right. Doesn't look like those sticks are hiding those girls at all. But I don't have another explanation to be able to consider. So I think this is one where as long as this has been preserved, as long as they did in fact try to uh, get into the details of the crime scene in the context of the Odinism, meaning like separate from the third party culprit stuff, then I think they're in very good footing here. It's clearly relevant.
Right.
It's relevant not just for this whole reason of it speaks to motive and means and what exactly was done and so forth, but it also relates to the next issue as far as the police investigation and the way that they, from the beginning had the experts involved looking at this saying, yeah, Odinism seems plausible. Yeah, this carries a lot of those hallmarks and so forth. Throughout the course of the investigation, they continued to have officers saying, we ought to probably look at this angle. And nobody ever came forward and said, this is clearly not Odinism, and here's why, right? It's not like there was something that disqualified it as a theory. And yet, for some reason, they just kind of totally abandoned and dropped it when they needed to do that in order to explain this is why Richard Allen is the killer, because those things couldn't be reconciled.
Right, and I don't know, is there a place later where they argue the state opened the door, they talked about it being an undoing, and then
Mhm.
this again became relevant? Is that in another issue somewhere?
I don't recall that came up specifically in the brief. Now, it's kind of I think it's implied maybe a little bit, because they do talk about what the state's expert testified to in terms of like the blood flow, the nature of the wounds and so forth. So I don't think they specifically use the words that it opened the door, but I think the general idea there is certainly implied.
Well, and it's one of the other things I did like a search for the words undoing, because to
Hmm.
me, that makes this argument so much stronger. They
Hmm.
told the jury not only about to hide it, but that it was an undoing. They
Hmm.
gave an explanation for why the sticks were there over and above just concealment.
Hmm.
And to me, that would have strengthened the argument. Do you think that,
Hmm.
nah, that wasn't needed, it wouldn't have really helped all that much?
Oh no, I think that it all goes to what exactly are you seeing here? The state is telling you you're just seeing ordinary consciousness of guilt stuff that somebody did to try to conceal their tracks, but that just doesn't make a lot of sense in context of this crime scene as a whole. The fact that it didn't conceal them, the placement of the sticks is not like the random kind of configuration you'd get if you just like tossed a bunch of things on them. If you wanted to conceal them, there are massive volumes of fallen leaves right here on the ground that you could have just, scooped over them. And then you would just have, looking from a distance, you would just have lumps of leaf litter on the ground. It wouldn't be remarkable at all. So there's inconsistencies with what the state is telling the jury, the explanation for the scene is. And so anything that provides an alternative explanation for why the scene looks the way that it did is potentially very helpful to the jury.
Right, because nobody thinks that that's hiding anything or an
No,
attempt to
and
hide
like, and
anything.
the puddle, the blood, like, why are you putting sticks on a blood puddle? It doesn't even make
Right,
sense.
right. What is this? So, and I feel like, and I don't know, would you have liked to see something in the facts about the fact that they searched all of his devices, his phones, his computers, and there's no history of any Norse paganism knowledge?
It might have been helpful. That this is another issue where maybe you just wait and see how the state deals with it, and if it's something that you need to point out in reply, like if the state tries to suggest, well, there's no way to know Richard Allen, could have been the Odinist or whatever, so it's harmless, something like that. Then you go ahead and point out, like, no, that's stupid because there's no evidence that he ever subscribed to anything like that.
Right, right. Okay, and so as far as this argument, um, on its own, you think I think it's strong? Do you think it's strong?
Yeah, I think this one is strong. I think this one is strong. Perlmutter was qualified. It was relevant. She had the expertise to be able to offer it. This is the issue that I always kind of come back to. People that criticize those of us who firmly believe that Richard Allen is not guilty of this crime, they like to kind of poo-poo and belittle, the Odinism, like it's the most ridiculous thing that they've ever heard. But the thing is if it really is the most ridiculous thing you've ever heard, then you would like want them to give that to the jury. Like, go right
Right.
ahead if you think that that's gonna help your position. If it really is that ridiculous, then you have confidence the jury is going to see it that way and is going to, reject it in a heartbeat. And you're going to have destroyed your credibility for everything else you're arguing in the meantime. So I think that it's the very fact that this has a lot of power to explain what happened that the version of events that the state offered does not, is precisely why the state fought so hard to keep it out, because they know it's more persuasive than they want to give it credit for.
All right. So a big one obviously is H. The trial court denied Allen his right to show the state's investigation was incomplete, overlooked
Mhm,
plausible leads, and mishandled evidence relating to third party guilt. Now, I
mhm,
mentioned earlier how Bob and I were, talking, during pretrial about, are they going to, give notice of their intent to point to third party, suspects? And I said, or I was just looking at a text, or are they just gonna use it to impeach the investigation? Like, what's their plan here? Because they hadn't given that notice. Now, I just don't know, and I can't remember. I think we might have forgotten to ask Andy when we had him on, did this evidence needs to come on you know, uh, to show the issues with the investigation, if that's something that was, specifically preserved, and maybe we'll see
mhm.
that in the response from the state, and then the reply. But Bob is like adamant about, and I like one of the big issues for me is like, why the hell aren't we talking that there was someone else who confessed to being involved in the crime? Like, why is
Mhm.
there no mention of Elvis? You were like, oh, I think it was fine to leave him out, or do you see that as something kind of big?
I mean, boy, it's this one is a tough call. Because yeah, Elvis certainly said things that are highly incriminating. Elvis does, fit within this framework that they're using of the suspicion related to Brad Holder and related to Patrick Westfall. I think the challenge with Elvis was not a strong record in being able to specifically connect him to Brad Holder, other than just through, through like he followed him on Facebook and kind of mimicked him on Facebook and things like that. So I think without being able to prove the actual connection, you run the risk of maybe weakening what you do seem to have as a pretty good argument that they really fumbled this lead, that these are highly suspicious people. These are people that have a connection to the victims, something that Richard Allen certainly didn't have. People that have the connection with the Odinism that he doesn't have. People that acted in consciousness of guilt kinds of ways, right? Changing their story about whether they know these girls, whether they've met the girls, deleting Patrick Westphal, deleting his phone before he gives it to police, things like that. The alibi that doesn't really, stand up when you actually go and look at it. I think you run the risk if you like follow the investigation too much. You might create kind of more of an impression that like, well, this is why it stalled, if it goes like so far afield and you can't kind of tie in every single lead, you almost give them a little bit of an explanation of like, well, that's why, we didn't go with Elvis because we could never tie Elvis to Brad. And so, so this whole like, connection doesn't work.
So you don't look at it like, well, they don't need to necessarily tie him to Brad. They can point to two potential suspects that weren't fully investigated, that could have acted alone or could have acted together. Your thought
I
is,
think you run the risk of diluting it, and you invite the state to counter that to the jury with like, look, they're just, they're shotgunning anybody that they can point the finger at to say that it's not them. I think the more you edit the case and focus on what is really your strongest point, the better, better position you're likely to be in, because there are a lot of good reasons to be super, super suspicious of Brad Holder and Patrick Westphal. And so really focusing on that, I don't take issue with that in the appeal standpoint.
all right. Well,
Because I really do think that was the strongest third party evidence that they had.
Speaking of strong third party evidence and facts that came out, this obviously was huge to me, because I'm thinking this at least gives the possibility, so in the weeks leading to the murder, Abby had been talking with a boy, LH, and meeting up with him a few times. She kept this relationship secret from her family. On the day she was murdered, Abby invited LH to meet her on the trails. He had school, so he declined. And then while law enforcement was searching for the girls on February 14th, they learned about LH and Abby's secret relationship, pulled LH out of class in Logansport, and searched his phone. At that moment, LH texted his father, Brad Holder, "She's missing." I'm like, holy shit. How did I not know about this? This at least puts in the field of vision the fact that Holder could have known precisely where she was that day.
When she was, yep.
And when she was going to be there. It's a definite nexus. It's in his field of, knowledge. And then couple that with the first thing he does when the cops pull him out is text, "She's missing." Not even, it's one letter more. Abby's missing. She's missing. I mean, to me, this is just, as far as like you're saying that there's so much to be suspicious about Holder, this is huge.
I agree. I mean, this was some pretty big new revelations from my standpoint. It really did provide a lot of new context to what Brad Holder knew and when he knew it. It does seem to provide more of an opportunity, for him to have, like you said, known where she was, when she was going to be there, and arranged to himself or some of his friends or whatever, be there and intercept or whatever. Then this interaction between between LH and his father. Wouldn't we love to know more about that? I mean, it's just kind of dropped in here. It sounds incriminating because it sounds like he already knows what he's being pulled out of class about. It sounds like, Brad is going to know kind of what the situation is. Why would they know? Why would this be something that seems to not require a lot of explanation between them? I haven't read Brad's deposition, so I don't know yet if any of this is fleshed out a little bit more in there. But it certainly seems like a reason to be looking at those phones and those text messages, doesn't it?
It sure shit does. And yay to us on 60,000 subs, and thank you to all of you.
Congratulations.
Thank you, thank you. And then I found this to be shocking that
Yes.
they, I'm like, what? In March of 2017, the police are using Holder as their source,
As an expert.
as their expert.
They're using
They're
him as an
consulting
expert.
him. It's
He's a witness.
outrageous.
They're relying on him while he still hasn't been cleared, right? They haven't cleared his alibi for another several weeks. So he should be under suspicion.
Right. And what it's shocking to me. It's
Yeah.
shocking to me. And then when you talk about the clearing his alibi,
Mhm.
I'm like,
Yeah.
obviously they put in here everything about like there's no cameras near there, they're not locked up, anyone could get his badge, da 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 da. But now you're
Mhm.
talking about they have these overlapping shifts from 5 a.m. to 1:30 and then a second from 7 to 3:30. This guy works until 2:45?
Just kind of in the middle, an hour and 15 minutes past his scheduled shift time. Why and who can confirm that? And what would he be doing? I mean, I have so many
Right.
questions that come up because of this particular piece of information.
And I have this flagged as to like next time we get Andy on to ask Andy, what was this question about in a deposition? Like, do people just willy-nilly get to work overtime? Is that a
Yeah.
specific request, a specific, you're thinking if they have these two overlapping shifts, it's sort of to avoid having to pay somebody overtime, you know?
You would
And
think like this is a particularly busy time, between 7 and 1:30. And so you basically have it double staffed.
right. And maybe the answer is, oh, people did that all the time. It's but it begs the question.
But
Like
it
that's
needs to
strange.
be asked, and that's the whole point of this assignment of error, is that we didn't get to point out how nobody was asking these types of questions about somebody who is highly suspicious. And
Right.
instead, they just took his word for it and said, fine. And then when it came time for Richard Allen, they not only didn't do that, they not only didn't take that approach, but they changed like all of their working presuppositions about how multiple people had to be involved, and it was Odinist related. And uh the two people in the sketches are different people. Now they have to be the same person again. It's just the fact that they weren't able to draw out all of those inconsistencies left the state looking like this was the end result, the natural conclusion of where their investigation took them. And they absolutely should have had a chance. The defense should have had a chance to be able to correct that.
So, what do you think the strength of that argument is? The specific, that they didn't investigate Holder enough, that and that they weren't allowed to put on the evidence, that they didn't investigate him.
Because it creates the false impression that the results of the investigation were inevitable, that it was always and naturally going to lead to Richard Allen, because they had no other possibility. They had ruled everything out, or the right tips hadn't come in, or whatever. And so for him to be able to show that that's not in fact the case, that goes to the argument he's made, the core of this brief, that the state had to build this case against him. And they had to do that not just with their deception and dishonesty and so forth, but they had to disregard the investigative choices and decisions that they had made previously, and they had to pretend like a lot of that stuff never happened. Otherwise, you get to the conclusion that this wasn't the inevitable like best suspect for them to settle on, because they bungled their investigation of their best suspect so badly.
Right. And do you take, the fact that they don't mention nexus, how to establish a nexus, what that burden at all, that standard at all, is that going to be a problem for them, or is it something
Well,
they can save for reply?
yeah, I'm not sure. And to me, it comes to the question that you raised about has this specific formulation here been preserved? Like, did the defense specifically proffer this evidence as going to impeaching the investigation, as opposed to simply pointing to a specific third party suspect? Because if they didn't, then I think we may have a problem, because you needed to raise the error in the formula that it was preserved in. And we know they wanted to present the third party culprit evidence. We know that Judge Gull ruled repeatedly, no nexus, no nexus, no nexus, would never explain what a nexus is, other than, there's no DNA. But, we know Richard Allen didn't leave any DNA either. So that doesn't make any sense as a standard. It comes down to preservation. If this was something that they argued as a basis for why they should be able to admit this evidence, then I think they're fine, because this is a little bit separate from the defense that I'm innocent because these other people did it. This is more of a defense of, you should have reasonable doubt because you can't rule out that police would have developed better evidence with respect to some other suspects.
But why
As long as
not
it's
put
preserved,
in?
I think they're in good position.
But why not argue? And also, the trial court erred in excluding the third party evidence. Why not raise that issue?
Possibly because you get there the same way, you get the
Unless
same
this
result
isn't
either
preserved.
way, and you have the more favorable legal standard here. This is just really a relevance type of standard. You don't have to get into the arguments about what's a nexus, what's not a nexus, and so forth.
Yeah, but if it wasn't specifically preserved, you should have, at least to me, thrown in the one that was clearly preserved.
Yeah. That's why it's the if. I am taking it on faith that it was, because
Right.
these are experienced appellate lawyers, and they're going to know, what the potential problems are going to be with any of these assignments of error that they've come up with. But yes, I agree with you completely that would be a concern if, in fact, this particular proffer had not been made.
Yeah. Yeah. So let's see. Alex Trev says, Allie, great show. I met Andrea and Lee one cold morning on the courthouse ramp. Love your insights. Was Rick's missing phone from the time of the crimes ever fully explained, as he supposedly had kept many others over the years? Thanks for all you do.
So the only explanation that I remember, and this didn't come out at trial. At trial, they just were able to paint this picture of like the only phone that they weren't able to recover was the one that he had during this time period. But since then, we've seen like the photographs from the search of his home and stuff, and what they were able to recover. And it's really not that clear, because they are lumping devices together to mean a lot of things. Like there's pagers in here, there's there's a lot of different stuff. And so no, in the sense that the defense never like strongly countered that. They didn't put out evidence that like there were other things that he had. They didn't like give us a timeline of what phone he had when, and what the, compare it to what the police collected, or anything like that.
Because I'll tell you, at my house, Andrea, there are probably in random drawers certain phones that have just we never like threw away, that we stashed,
Yeah.
and then other ones that we just they broke, we threw them away. We just threw them away. Now almost always swap the phone, but I'm talking years ago. So they could come into my house and be like, they've got every phone. They've got their phone from 2005. They've got but what, you don't know how many phones I had in the middle that aren't here right now.
Yeah.
Like
Yeah. Like, I have my phone that I dropped in the pool. I didn't keep that phone. That phone, is dead. That phone just got, the SIM card busted and whatever,
Right, you got a phone you dropped in the toilet, you never took it out? I mean, I'm just
yeah,
saying, like, you're
yeah,
out
but,
in
like, the
public.
ones that I just upgraded, are probably, like, still around somewhere, so no, I don't think that a real clear story on what the police got and what they claimed, was absent was ever really strongly countered by the defense.
Right, and I mean, I don't know if they were literally to say, "We know every phone this family ever had from this year to that year, and every single one was there, but this one." I thought at some point that his wife said it got run over by a somebody said something about a lawnmower. Now, I don't know if that was at trial or just something that we heard,
Yeah, I don't think
um,
that was at trial.
but yeah, I think that's everyone's question. So that's the last of the issues that they raised. Is there anything else, overview thoughts that you wanna share, discuss, anything?
I mean, I think we've been pretty thorough. The main thing that I just want to, continue to reiterate is that for all that I'm very black pilled on appeals, in general and their likelihood of success, he's in a pretty good position here. I mean, if I'm an appellate lawyer and I'm handed this case and I'm filing this brief, I feel a lot better about this one than I do about, probably 95% of my other cases. So yeah, you're always at a disadvantage on appeal, but he does have a lot to work with here. He does have some good arguments, and he's got a good story to tell about why the court should care to fix this and make it right in the first place.
Agreed, and I know there's some other comments and some, new members. I'm gonna address you guys all. I just wanted to let Andrea go and thank her for her time. So thanks
Well,
for joining us. I think this was great. Hopefully, everybody else got a lot out of it. I definitely enjoyed it.
yeah, very much. And thank you so much for getting to have this conversation with you face to face. Because one thing that you don't know that I'll go ahead and mention is that I have been listening to Bob religiously on my walks with my dog because I'm addicted to the Buried podcast. I
Uh,
finally got caught up, and it has just been like I'm on pins and needles waiting for the next episode every single time. The amount of expertise that Bob has about that John Wayne Gacy case is absolutely unbelievable. And the, twists and turns that he's uncovered that I'm not going to spoil for anybody that hasn't listened to it, but that are extremely compelling parts of the story. It's just been a great listen. And so I feel like I've had, a lot of chats with you, but of course I haven't. So being able to do it in person is
well
pretty awesome.
well, maybe after the last episode drops, I'm sure Bob would love to have you on because I know he loves to discuss with another lawyer, like, all those little things that, like, people are like, "That doesn't really matter," but it's raises a lot of questions about,
Mhm.
overstepping, and does it matter who the end defendant is, and you'll be a great person to talk to about that, so that,
Oh, I'd
those
love
are
to.
very kind words. I'm sure if he's listening, I don't know if he is, I know greatly appreciates that because I'll tell you, I'm biased, but even when I was, like, honest to myself, I'm like, "This shit's amazing." He did,
Mhm,
like, such a good job,
mhm.
and I'm like, "The rest of the world needs to know this is amazing." So I appreciate the words on that, and I'm glad that you have been enjoying it.
I'm
So,
hooked. I'm hooked.
all right, well, have an amazing Christmas. Thanks so much, and, talk to you soon.
Thank you. We'll see you soon.
All right, bye. All right, guys, that was great. That was great. So there's some other comments. Don't think I forgot you. So Bailey says, "Congrats on 60K. Y'all have taught me so much, and I'll be a self-appointed Mata for life. Your knowledge is invaluable to us, normies. Let me know when you're taking our 2026 family Christmas card." All right, Bailey. Thank you. And we got lots of new members. We got maybe Megan, maybe not. We got uh I keep wanting to say Red, but Redonda Beach. We've got so welcome new members. Aw, family hugs. And then Petite Betty gifted 10 memberships. Then she came back and gifted 20 memberships. Catherine gifted 1 membership. And Devon Decay, I hope I'm not butchering that. Oh, Dr. Vonda Gay. Oh my gosh. Hi, Dr. Vonda. I am so sorry. Bob's going to be like, what? It's just like the reading sometimes. So gifted 5 memberships. She's always good for generosity. Sharon the Mex gifted a membership. And then Petite Betty came back again with 20 more memberships. Sherry DV gifted 1 and then 5 new memberships. So I appreciate all of you guys who gifted new memberships or gifted memberships. Thank you very much. And we also have Brains and Brawn who became a member. Aw, family hug. So thank you all for becoming new members. Thank you all for your comments. This was a lot of fun, and I hope you guys enjoy your holiday, that you're with your families and having so much fun. Um, this shit can be heavy, and we need to, find ways to consume it in healthy ways. And I think that this community of now over, I think, 60,000 has really found a way to do that healthy and responsibly. And I'm really, really proud of that. And I know Bob is really proud of that. So thank you, mods, so much. Thank you, Tracy. Oh, I think there was another comment here that I forgot to highlight. Oh, here it was. Sorry. Sherry DV, 60,000 subs. Congrats, Allie and Bob. Tracy gets her bonus. Well, thank you, Tracy and Mandy. Thanks you, all of our subs, all of our mods, and thank you to all of our subs and for all of you for joining us tonight. And we'll see you after the holidays. Thanks again. Bye.